it stops, no one knows. We're going headed into the unknown. Na, 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 na.
Well, hello, and happy Monday. I swear it should just be like the theme song for Monday should be like Manic Monday when it comes to this case, because here we are, another Monday, and more craziness has ensued. And hello, everybody. Hi, Sleuths Investigate. Hey, Julia. Hey, Little Cause of Tea. Hey, Danielle. Hi, Angels Live. Pointer Lover. More Insanity. What's up, Ava? Hi, Python Chick. Hi, Terry. Hey, Sleuthy Goosey. Hey, Shelly. Hey, Shaz. Angie Baby. What's up, Angela? Because Justice Warriors work 24/7, even through the weekend. That's right. Hey, Charismatically Clever. Hey, Julia. Hey, G. Turner. Hey, Missing Unsolved Crime. Yes, so we have quite a few new documents, some repetitive stuff, some interesting stuff, and hey, Freckle Joy, KW10, hey, Lacey, some newer information or stuff that we knew, but we actually get some clarification on. So I wasn't live at the end of last week, so if anybody missed it, which I doubt you guys did because you guys are on top of it, the attorneys that have filed with the Supreme Court to have the record clear or record completed and put back together, and Judge Gull doesn't want to have a clear record for this case for some reason. They had requested a few different things. They requested the transcripts for the in-chambers hearing on October 19th. They requested the transcripts from the hearing on October 31st. So they put in a few requests for the case. And in turn, Judge Gull decided she was going to get herself some attorneys. So she first asked the Indiana Attorney General for some help, who declined. And then she put in for a continuance, essentially for 5 days, with the Supreme Court to be able to get her shit together to give to them. With that, it kind of showed that the appellate attorneys were not done submitting motions. So this was somewhat expected. I declined too. Yeah. Well, that Attorney General is already kind of on the outs. He's getting some criticism from the public as it is, so it would not be in his best interests probably to get involved, or maybe he just wants to stay like impartial so he can come in later. I don't know. We'll have to wait and see, I guess. Got my butt chewed out. You got your butt chewed out? Oh, you did, Freckled Joy. You did. There was lots of blocking and all kinds of stuff happening over there. It was crazy. Hi everybody who just came in. See Dub, Lunch Lady, Marshall. Hey Lilith. Yeah, you're welcome. I know. I could hear the conversation in Lilith, and I was like, okay, let me just pop in real quick. No, did he really? Oh, I didn't hear that, Freckled Joy. I was doing dinner and trying to listen at the same time. Yeah, I know. I had to message Sleuthy because I was like, I literally started to read the comment and it was just gone. And I was like, maybe something at the end of it was bad, but whatever at the beginning of it wasn't. But it just gets kind of chaotic. And that's one of the things about like a case like this. And it was the same way in the Watts case, same way with Summer Wells. It turned into the same thing with the Idaho case. People get very touchy. And because there's so much animosity towards each other, it's almost like you can't even read the comments in a like unbiased way. Everything comes across very harsh because you're almost so tense. And trust me, when I've had lives where people come in and they get like, there's just like a lot of fighting, it just, you don't even know anymore. You're just like, I don't know who's saying what, or, but that idea, I didn't know that. So Judge Gull goes and gets her own attorney. She files for the continuance. They put in all these motions, and we were like, okay, so there's more coming, because they're not requesting all of this stuff because of the record. So we knew that they were going to be putting something else in, and I have to cough. Give me 1 second. So today I literally wake up and there's already, everything is going crazy, and I got to take kids to school and do all my regular morning stuff. So I'm like, all right, let me just start reading through this and see what we got. And we definitely got. Okay, so there was a lot of stuff filed. Like I said, a lot of it is kind of repetitive. So I just want to go through some of the key things that I think are the most important. So we'll touch on that first. Yeah, I didn't really understand that myself, Freckled Joy. I was really confused by the whole. I don't know. I'm still working it. So even though I haven't been live, I have been working on stuff when it comes to the Delphi case. I've got different timelines of different things going on, and one of them has to do with that damn leak. Because I'm not sold that it went down the way that they're trying to sell it to us. I'm not. All right, so let's start into this stuff, because we might be here for a while. In the MAM community too right now. The Rockaways, yes, she is. She's just like, and then she's like tweeting about it. I'm like, oh, she's like on it. She's like, I don't give a shit. I'm gonna tell him exactly how I feel. Crime Curious. I have some new PDFs for you, love. So if you guys don't know, Crime Curious has a website called crimecurious.com. She also has a YouTube channel, but she puts all the court docs up, and for a few different cases that she follows. She's also been getting the case file for Gannon Stauch. So she did you guys probably know, because she's the one who did the read through of the 136-page memorandum for her bedtime stories. So you should check out her channel. KW, you missed these updates. Oh man. Yeah. Well, this is all just coming out today. It's all just coming out today. My dog is trying to get in. Give me 1 second, you guys. Sorry. But Crime Curious, so she puts all the court docs on her websites, and as we know from following the case, the judge likes to take down those court documents. So it's nice to have them all in order in a nice, easy downloading space. So check out crimecurious.com. I'll be right back. Okay, and we're back. So the first one I'm going to touch on is just the brief. So the way that these court filings go, it can get kind of confusing because it is really repetitive. So essentially what you really want to kind of look at is the brief or any evidence that they put in to support their brief. There is, I'll show you these real quick, just because this does get people confused, and I've already seen people commenting on it. These, this is an emergency writ. So this was also submitted today. This is written by the appellate attorneys. It's not from the court. It's making it really easy for the court to say, for the Supreme Court or whoever is looking at this, to just go, okay, here's exactly what they need, and here it is as ordered, and sign off on it. These are not from the Supreme Court. So there's people who are already commenting on social media that it's already been ruled, and like the Supreme Court's already made like this happen. Like, that's not how it works. This is them submitting. And if you look at, like, it says it's a proposed document. So this is the proposed emergency writ that is submitted to the Supreme Court, so that they have it right there, and all they have to do is essentially sign off on it on the day that they do. It's done. So there's a couple of these. And this one is the permanent writ of mandamus, and then it's just ready for them to go. But you got to pay attention to, this is all from today, Cobalt Blue. Yeah. So you just have to just take it. Make sure you look at the proposed. Make sure you look and see if it's signed off. Make sure you can see that there's a date that it's actually ordered. This isn't the Supreme Court ordering anything. So just keep an eye out on that. If somebody says that the Supreme Court did the order, they should have a copy that looks. Hold on, let me see if I can find the last one. If I have it handy. Is this it? Yes. So this is what like an actual filed order from the Supreme Court would look like. So just make sure you're looking for that, and you don't just take the other documents that are on there. I don't know if it's that they can't handle the truth. People get set in their ways, and there's quite a few of those people that you named that I enjoy watching. But people get so set in their ways, and sometimes it's hard to get people to see things differently. And I get that, and that's one of the reasons. And I'll be very honest, like, I stopped following the Watts case because I have my idea of what happened, and listening to other people talk, it becomes almost like an argument with people who have a different perspective. And it's like, then you have to go and you have to pull all the stuff to prove that what you're saying is accurate. And it just becomes like an unnecessary fight, because my job isn't to change anybody's mind. My job is to deliver information and process it with you guys. You know what I mean? Like, that's how I feel about it. I don't want you to walk away feeling like that I gave you a narrative that you have to believe in, which is why I try to keep everything as open as possible, because I do enjoy people with different perspectives. That can put up, a conversation or argument, not with fighting, but like an argument on behalf of what they have. And so I get where they're coming from too, because I was that person. I'm not there yet with Delphi. And one of the reasons I have now been stuck on Delphi for over a month is because I can't put my own, I can't match a simple theory of how I believe everything happened. And I don't have to know everything, but I mean, just the essential pieces that make sense to me. So I don't hold anything against anybody for having their opinion. I do not like the name calling. I think it's unnecessary. This is YouTube. Like, we don't have to hate each other to have a conversation. Oh, thank you for joining, Lilith. I appreciate that. So I just don't. I don't want to fight with anybody about it, but nobody should be called names over a true crime case on social media. Like, this isn't our real life. It's our real life, don't get me wrong, but they're not our kids. You know what I mean? Like, they're not, it's way different for that type of fight. But don't stress it. They don't want to hear what you got to say. They're not open to it. Don't go. That's all I can say. Yeah, I absolutely love people with a different perspective. So yeah, that's right. That's right. I don't like it. Yep, that's it. No more Chris Watts solves for me. I've got what I feel is necessary with Chris Watts. So I don't feel like I need to talk about it anymore. Okay, let me go back to the other screen so we can go back to today's stuff, because that is not today's. Now I lost all my stuff. Okay, here it is. So the biggest ones to look at, in my opinion, would be the brief and any type of evidence that they put along with the brief. I think they all probably talked to Holman at this point. I don't know. Nobody really should be talking to Holman unless they have a tip, but that should go through a tip line, so it's all straight and narrow. But who am I? I'm just a girl on YouTube. Yeah, be kind. But I mean, like I said, I don't do name calling. I'm not going to sit here and call you guys idiots and words like that because you think differently than I do. That's silly. All right, let's blow this up. Let's get to it. So this is the brief in support of their writ that they filed. Like I said, it was pretty apparent this is coming. It kind of gives you just like the index. This is what we're going to be looking at, so on and so forth. The trial court, and then they go into a little bit of the background. Yeah, I'm like, I don't know why anybody's talking to Holman, but that's what I'm not trying to put my spin on it, but I wouldn't be talking to Holman. That's like not the guy that I'm like, oh yeah, he's the one that I want to give all my info to. He's not. I got trust issues. So I'd probably be trying to get a hold of Murphy, Honest Murphy, or Click. Sick of gray anything. Yeah, but why does that, Shelley? Yeah, why is that important? I just don't see it. I don't. There's a very big deal when it comes to social media about being first. Hi, Salty C. For when they call me, you're still waiting. I think that they've been on hold for a really long time, Christine. I don't know if they're going to be calling. Okay. Everybody in my house essentially has had a cold the last 4 days, and so I've been doing my best to fight it off, but like I have this stupid cough, so I'm hoping it doesn't really wreck a live, which is one of the reasons I wasn't live at the end of last week, because reading anything has been quite a pain in the ass. You heard it here first. I don't know what it's about, but if you heard it, you had to have heard it here first. It'd rather be first than accurate. Absolutely. Okay, so the introduction, and obviously most of us know this stuff, so we're just going to go through it. Over 5 years after teens Abigail Williams and Liberty German were brutally murdered in Delphi, police announced that they had arrested Richard Rick Allen for the murders, concluding a police investigation that has captured the world's attention and involved thousands of tips. At his initial hearing, and clad in protective gear for his own safety, Rick told the court that he would be hiring private counsel. Rick was transported to the DOC for quote-unquote safekeeping, and then the judge removed himself from the case, which they don't put in here why they removed themselves, which is interesting to me. And the special judge was appointed. But a week later, Rick threw himself at the mercy of the court and requested a public defender. Andrew Baldwin and Brad Rozzi, attorneys with combined 50 years of experience, were appointed. And over the next year, attorneys Baldwin and Rozzi zealously advocated on Rick's behalf. They appropriately asserted Rick's innocence. After the public release of the probable cause affidavit, they repeatedly requested a change in the conditions of his confinement due to the obvious effects the conditions were having on his physical and mental health. And they prepared a trial strategy with Rick after pouring through thousands of pages of discovery to prepare his defense for a January 2024 trial. During that time, Rick never complained to the court about his attorneys. On the contrary, he unequivocally stated his desire to have attorneys Baldwin and Rozzi continue their zealous representation. Yet, less than 3 months before trial, the court removed attorneys Baldwin and Rozzi as counsel, citing its extrajudicial finding, quote-unquote finding, that the counsel had engaged in gross negligence. At Rick's direction, attorneys Baldwin and Rozzi entered appearances as private counsel, agreeing to continue representing him for free. But at a hearing held on October 31st of 2023, the court told Rick that it had grave concerns about his defense team, that he was entitled to a vigorous defense, and that the court cannot and will not allow these attorneys to represent you. I can't do it, sir. I just can't. Rick's trial has been reset for a year from now, and he has been forced to start over with new attorneys. The court's statements about Rick's counsel have completely undermined the credibility of Rick's proffered defense. Rick has an original action currently pending in this court under this case number concerning the lack of public access to the court records in his case. The lack of transparency is an important societal interest, but the issue here implicates Rick's fundamental constitutional rights to counsel in a fair trial. So essentially, we know all of this, but I do find there's a. I'll get to that in a minute. Never mind. Strike that. The background. Rick requested and was appointed competent and experienced counsel. On October 28, 2022, the state charged Rick with 2 counts of murder. Officers arrested Rick and took him into custody, where he has remained ever since. The Carroll Circuit Court ordered Rick transported to the DOC for safekeeping due to a quote-unquote a toxic and harmful insistence on quote-unquote public information from the media about the case. After sending Rick to the DOC, the judge recused himself for fear. He was afraid of the bloodlust. The Honorable Francis C. Gull accepted an appointment as the special judge. Rick requested a public defender to represent him. Attorneys Andrew Baldwin and Brad Rozzi were appointed as Rick's counsel. Attorney Baldwin is one of only 4 Indiana attorneys certified as a criminal trial specialist by the National Board of Trial Advocacy as authorized under Indiana Rule of Professional Conduct. He has nearly 30 years of criminal trial experience, handling hundreds of jury trials and representing numerous defendants charged with murder. Attorney Baldwin has never been disciplined or suspended. Attorney Rozzi has over 20 years of criminal trial experience, handling thousands of cases, including 8 murder cases. Attorney Rozzi practices regularly in Carroll County and surrounding counties. He was born and raised in the adjoining Cass County and is intimately familiar with the police officers and prosecutors investigating and prosecuting this case. I thought that was really interesting. Attorney Rozzi has never been disciplined or suspended. Rick wants this partnership to handle his defense. Rick's lawyers issued a press release affirming Rick's innocence. On November 29th of 2022, the charging information and probable cause affidavit in Rick's case were made available to the public. Attorneys Baldwin and Rozzi issued a press release, which responded to the allegations contained in the affidavit. They reasserted Rick's innocence and indicated they would continue to share any exculpatory information with the public to the extent that they were ethically permitted to do so. Later that day, the court entered a gag order prohibiting the parties from making extrajudicial statements about the case, which was reaffirmed after the hearing. The court also entered a protective order prohibiting the parties from divulging or granting access to the discovery material to all but certain people. I'm hoping that those certain people would only be the people in their office, but the people who are actually employed by them. Let me see what you guys got going on here. Hold on. Hey, Candace. I don't think that they would be allowed to do this. The fact that they want to do it for free speaks volumes to me. Yeah. Love Don. Hey, I agree. I don't need to be called an idiot. Yeah. It's so stupid for thinking differently than me. Go Baldwin. Facts don't change. Info can be added to change the interpretation, and lies can be uncovered, but the facts don't change. 1,000%. Right. Yeah. No, can't have them that close. That's just crazy. All right. Let's see. Hey, Commander. Is there a response? All right, I'll double check that. Let me pull it. Let me see if there is. Does it give them a? Does it say that they're going to take the application on? Do we know? can't get anything to load, so that may not work. Let me close it and try it again real quick. Otherwise, I'm just going to go back to this, and I'll look again in a little bit. Yeah, I don't see it popping up, but that doesn't mean that it's not there because I can't get it to load right. So we'll just keep going, and then we'll see. If any of you guys have it, you can just you can send it to me if you want. Hey, J.E. Everett. Yes, one of the new lawyers is Facebook friends with the judge. Yep, and her old Facebook account. Okay, perfect. Thank you, guys. Let me pull it up. See if I can get Facebook to load. Sweet. So it's jumping ahead of the game a little bit, but that's okay. I probably just have too much shit open on my computer. My computer's like, stop trying to make me look at other stuff. So the relator, Richard Allen, by counsel, has filed a verified petition for an emergency writ of mandamus and prohibition, seeking relief under the rules governing original actions. Any briefs opposing issuance of this writ or any supplemental records must be filed directly with the clerk of the Supreme Court on or before Thursday, November 16th. Any supplemental record must be submitted in the same format required for the record under the original action rule. One briefing is completed, the court will take the matter under advisement. Okay, so the petition for an emergency writ of mandamus. Yeah, that's and she's giving them to the 16th. That's 10 days. All right. Thank you for sending that. Hey, Julio. Does that facility have the protection and medical care that Ari needs? If it does, then indeed move him. Well, I think that's kind of up for debate because depending on what side of the fence you fall on, the prison system is supposed to have better medical care and better mental health care. But if he was the biggest thing, and I don't want to go too far backwards, but the biggest thing they said was that one of the reasons they moved him was for his own safety. And when he got to Westville, he was talking out loud, essentially, and having suicide thoughts. So he was being put on suicide watch, and he was going to get the mental health, help that he needed. But by, I think it was the beginning of May, and the visit that Baldwin and Rozzi had with him was when he was like incoherent and babbling and like drooling. And so when we see the picture of the shirt, so then they go to court in June, and the warden comes in. They're like, no, he's doing great, and he spends his commissary money on clothes. We don't know why he just chose to wear those clothes, blah blah blah. But so depending on where you kind of fall in the line of things, did it help him because he obviously didn't commit suicide, or did it hurt him because his mental health has obviously continued to deteriorate? Many say that that's probably not true. She's just faking it, or there's the guilty conscience, or there's, prison isn't a good place. It's not supposed to be, but he's not been found guilty, so it really should be. My issue is that he isn't going to receive the same treatment as somebody who is in a jail that is not convicted of a crime. Yes, there's still bad guys there, but not the really bad guys. And then they lock him up for basically 23 hours a day. And I thought it was really ironic because one of the arguments in June was that like Cass County and Carroll County, like they don't have a basketball hoop. So he can't go outside and play basketball. And I was like, how often is this guy going outside and playing basketball as it is? It was just so, I don't know, it's so bizarre. I was like, that's the weirdest argument like ever. But okay. So for me, I I think that you have to count. You have to go with what the mental health people are saying, and they're saying that he has deteriorated to the point where they were talking about forcing him in medication, and then come May when they went to visit him, he was supposedly drugged. There's a lot to the whole thing, and I just don't think it's the right place to be. And it's one of the worst correctional facilities there. And if it was, for me, the biggest thing is, why does the investigators or the prosecutors, why do they care if he's in the prison or in Cass County Jail? They think he's not safe in Carroll County, but why do they care? Why is it such an important thing for him to be in Westville that they fight it so hard to keep him there? That's the most interesting piece to me. Okay, so on December 21st, 2022, Rick's counsel, Andrew Baldwin, inadvertently emailed a summary log of the evidence on a flash drive received during discovery. The log did not contain any substantive evidence, but was similar to a table of contents. So this is interesting because I also thought that Brandon Woodhouse didn't get that until April, according to one of his lives, because he was talking about that he got it on Easter morning. So I'm curious about this. But it is that same summary log of evidence that we've kind of gone through. We only have the pieces of it. Yeah, like he's eating his mail. Okay, never heard of people having to do that in prison. Well, the excuse is he didn't want anybody else to see how all the evidence against him. It depends on it depends on who you talk to. For me, it's like, okay, the guy's eating freaking paper. There's probably something going on. So I just don't see his mental health being fixed at all. I think it may, you can say it didn't get worse because he didn't commit suicide, but maybe it went completely different. Hey, Steve. Hi, on Master Truth. Westville is an intimidation tactic. They want a confession. It reminds me of the stories we heard about Ron Logan. Remember when they put Ron Logan in and they said, his friends that were speaking out were saying like they wouldn't give him his dentures and they were making him eat like hard food, and like how they were like basically like torturing him in there because they were hoping for a confession. Easter morning is when they arrested him. Oh, maybe that's why I'm stuck on Easter. So December 21st, that email goes out. Due to his declining mental and physical health, Rick asked to be moved out of maximum security segregation confinement. And on April 5th, 2023, Rick moved to modify the safekeeping order, arguing that he was unrepresented when the order was entered and that no hearing had ever been held on the motion, that he was being held in a maximum security segregation unit at Westville Correctional Facility that is generally reserved for violent convicted offenders, and that WCF had a history of unequal and inhumane treatment of its inmates. And that's all documented too. So it's not like the defense team isn't just making that up. Like that's documented over the years that they have had that history. And why they're sticking him in this maximum security segregation unit that's only for violent convicted offenders just blows my mind. Why does he need to be there? And if he's not a risk of suicide anymore, then why is he still there? If he's gotten so much better, right? Because that's the thing. It's like he's gotten better. He didn't commit suicide. So then why is he still there? Rick described the conditions in which he was being held as well as the obvious decline in his physical and mental health. Rick explained the significant hardship his placement in WCF had on his ability to assist his attorneys in preparing for his defense. And that is huge because that's going to go to competency, and that goes to an appeal. So the court has to take that seriously, because if he can't actually participate in his defense, then you have to have him deemed incompetent. Was that something they were going to do? No, they're trying to get him moved. They could have delayed the thing for a long time. Look at Lori Vallow. How many times was that lady deemed incompetent? There was one that she was like away for like 10 weeks. The court denied the motion and reaffirmed its prior order and clarified that the DOC could move Rick to accommodate his needs. Attorney Rozzi filed a tort claim notice to preserve Rick's right to obtain private counsel in the future to file a civil suit relating to the conditions of his DOC confinement. She talks about this tort later on and how, you know, as his defense attorney, he wouldn't typically be the one filing it. It comes up later when she's, you know, talking about all the things they've done to essentially commit this gross negligence. Rick and his attorneys formulated a strategy of seeking a speedy trial and pursuing a defense of third-party guilt. Rick's counsel continued to file motions to change his confinement conditions. He and his attorneys, there was still one pending. He and his attorneys also developed a trial strategy of seeking a speedy trial and pursuing a defense of third-party guilt. Several months before trial, Rick filed motions to suppress evidence, a motion in limine regarding the ballistics evidence, which I don't think that's ever been ruled on still. If it has, I've never seen it. And a request for a hearing under Franks v. Delaware. So we know that she said that she didn't get through all the stuff from the Franks hearing, which I mean that was like over a month later, but that's interesting. But there's a couple of those. I don't think there was ever any ruling on them, and I'm wondering if they mentioned the motion to have him moved, if that was done before she gave them the ultimatum, the alleged ultimatum. And the Franks here, the Franks motion, she requested it because they were supposed to cover that in the June, was it June or July? In the summer hearing, I think it was June, hearing that when the warden came in and they only ended up talking about his conditions. They didn't actually discuss the motion to suppress evidence, and she said, no, you guys are going to need to essentially do a Franks motion. And then she gets pissed off at him for their Franks motion. It's funny. Rick also signed a motion. Oh, we already did that one. No. Rick also signed a motion for a speedy trial, which Rick's attorneys plan to file in early November to lock in the January trial date, which I find interesting too. There's so much I find interesting about this, so I keep saying that over and over again. I apologize, but I find it interesting because they said they had 30 to 40 more depositions to do. And I was really wondering if they were going to be able to make that trial date, but they're saying they were. And I don't know if that's now or if they have something that proves that they already actually had done it or that they were already preparing for it. Oh, thank you, Shelly. Hey, BR. Hey, Bushi. Roxanne. During a conference with the court in early October 23, Rick's attorneys informed the court that they were ready to proceed to trial in January. During a telephone conference with the court in early October. In early October, I wonder the date of that, because that, you know, we talk about the dates of the leaks and being the 4th, the 5th, the 6th. The trial court removed Rick's chosen counsel over his objection. In August 2023, a former employee of Attorney Baldwin's office, Mitchell Westerman, stopped by Baldwin's office to visit. Westerman slipped into a conference room where he found crime scene photos and, by his own admission, secretly photographed some of the discovery material and disseminated it. Attorney Baldwin was not aware Westerman had done this. He slipped into the conference room. When counsel learned the material had been disseminated, they disclosed the matter in an email to the court and the state on October 6th. The prosecutor responded that he had known about the leak for a day and that the state was investigating the matter. On October 9th, Westerman told Attorney Baldwin about his inappropriate, if not criminal, conduct in secretly photographing the discovery items. Rick's counsel informed the state and the court the following day. The parties had a telephone conference with the court that day to discuss the matter, and the state mentioned the issue of disqualifying counsel. A day later, counsel informed Rick of the matter, and Rick immediately and unequivocally indicated he still wanted his attorneys to represent him, believing their representation was in his best interest. This letter was filed with the court on October 12th as an attachment to a letter filed by Attorney Rozzi. After receiving Rick's letter, the court notified the parties that it was scheduling a hearing on October 19th to address other matters which have recently arisen, and ordered Rick's counsel to cease work on Mr. Allen's case until we meet on the 19th. On Rick's request, the court ordered the attorneys to appear in chambers at 12:30 p.m. before the hearing to discuss what was expected at the hearing. Attorney Baldwin filed a memorandum regarding a possible disqualification or a sanction, explaining that the circumstances regarding the theft of discovery, the law regarding a criminal defendant's constitutional right to counsel, the court's limited authority to remove appointed counsel, and a proposed sanction in the event it was warranted. On October 19th, the judge opened the courtroom to the media and for the first time authorized 1 or 2 cameras providing pool coverage to be permitted in the court session. The attorneys appeared in chambers without Rick being present. During the conference, the trial court read a prepared statement to Rick's counsel accusing them of gross negligence and citing specific examples of their zealous advocacy and purported acts of their negligence. These purported acts of gross negligence include the following: issuing a press release before entry of the gag order, filing motions to protect Rick's health and safety, which the court believed lacked evidentiary support, unintentionally emailing a discovery log to a third party, unspecified improper statements made in the motion to suppress, filing a tort claim notice to preserve Rick's right to seek redress for the conditions of his ongoing confinement. That's the tort, that we were talking about earlier that I said would come up later. Attorney Baldwin hiring a lawyer to appear on his behalf on the issue of sanctions or disqualification, and a third party impermissibly photographing discovery without the knowledge or consent of either lawyer. The court then informed Rick's attorneys they had 2 options: 1, voluntarily withdraw their appearances, or 2, be disqualified as counsel after the court read its prepared statement in open court. Attorneys Baldwin and Rozzi met with Rick to discuss the matter. Rick disagreed that his trial counsel had engaged in any negligence, and he reaffirmed his desire for them to remain as his counsel. Rick's attorneys informed the court that they believed the court had engaged in an unconstitutional ambush of Rick and his counsel without due process. So this is important because Rick, this is where everything kind of gets wonky and people are like, it doesn't matter, they committed gross negligence, she did them a favor and let them go, and instead of embarrassing them and whatever. Here's my main issue is that Rick isn't there for any of it. So the person that everybody's supposed to be protecting their rights doesn't even get to be in the room when it's happening. All of these conversations are all happening without him. So all these decisions are being made where McLellan's like, yeah, they should be disqualified. Well, why should they be disqualified if that's who the defendant wants? Why would the prosecutor get to pick whether the defendant gets those attorneys or not, no matter what they did? And I think that this is kind of the issue. They didn't send it out. They have statements that show they didn't send it out. They have statements that show that they didn't purposely. Yes, was it bad that it happened? Obviously. But is it gross negligence? And I think that this is where people don't get the due process that Rick didn't get. Is the attorneys also didn't get their right to due process, which would have been for them to know that this is what was happening. They assumed, but they didn't know because she wouldn't tell them what the hearing was going to be about, which is why the statement from Hennessy is essentially a proposed statement. It's not, a motion being submitted saying, hey, here we are, we're standing up and we're going to fight this. Not yet. It becomes that later, but they didn't know that this was taking place because she wouldn't tell them. They could have brought in witnesses to support what happened. They would have had Mitch up there saying this is what happened. They could have had, experts on, what's deemed negligent. They could have had other cases where gross negligence was cited, but attorneys weren't removed. I mean, they weren't able to prepare for any of that. And essentially that's due process. So if the end result is they really did do something really, really bad and there's more to the story that we don't know. The attorneys could have spoken in open court. I disagree. I disagree with the outcome, is what I should say. Because and this is why I disagree. Well, okay, I'm going to rewind for a second. We don't have the hearing. We don't have access to the hearing. They won't give up the hearing, and we're going to learn later on as we read through this, they won't even give up the hearing for this, which they're going to have to, but that's another story. The court will not release it. The court clerk could not give it to these attorneys. They do not have the transcript still of what happened in that room. That's problematic. So ultimately saying a decision, or us making a decision based on information we truly don't have, I don't want to do. So everything I'm saying is because of what we know going into this and what we know from the documents we have. But until we hear that, we can't actually say one way or the other how she said it or what she said. But my opinion is they couldn't go in the courtroom because they didn't have anything prepared to go fight with. So they would have had to have stood there and been like, okay, read your statement and I guess we'll go. There was no difference in those two things to them except the public shaming on television, which also hurts their career. But more importantly, that is, talk about tainting a jury pool. That's going to make Richard Allen look worse. So I do not think they should or could have spoken in court. That's my opinion. I think what they did at the time, if what they're saying happened and she was in there, and I said from the beginning, my gut instinct was they were in there like yelling back and forth, and it was like everything's up in the air. I'm not yelling, but like very stern, like you're in trouble. If that is true, they took it and they walked so they could figure out a way to fight. And the way that you fight in court isn't by going in there and yelling and screaming. You have to go in there with precedent. They have to go in there prepared. They have to go in there with witnesses. So they didn't protect the evidence in their possession. I have no question about that. I have no question whether they protected the evidence in their possession. My problem is this middle part. So this is what I'm saying. Even if they had gross negligence or anything that ultimately could or would disqualify them, why can't she do it the proper way? That's it. Then we would all know, everything would be on the court record. We'd all be like, holy shit, these guys are really bad. They really shouldn't be there. And most of us would all be in agreement. We wouldn't be here like talking back and forth about it. My issue is her lack of doing it the right way. She gave no due process to the two attorneys, which is their constitutional right. And more important, she gave no due process to Richard Allen, who is the one who's on trial for his life. You can't just go, well, I feel like this is how it's going to end up, so I'm just going to go ahead and make a summary judgment and say you guys committed gross negligence. Now, if they're sitting back there going, yeah, we totally lied to you and we did this and we did that, and we hear a totally different thing when this transcript comes out, if it ever does, which I'm not sure that it will, then I might err on the other side. But as of right now, I do not feel like this went down correctly. And my gut told me that day something was wrong, because she made this statement in court to McClellan. I know you've been here for hours and you brought witnesses with you that have been here for hours also. Why would the witnesses have been there for hours? Why would the witnesses show up to an in-chambers hearing? That make sense to me. Why were the witnesses there when the lawyers got there? If the court hearing wasn't supposed to start till 2, and everybody wants to say everybody knew what was happening. If I knew, then they knew. Everybody knew what was going on. That's why they brought their attorney. Okay, great. Why were the witnesses there hours beforehand when they would not be needed to testify until 2 o'clock? Why would Doug Carter be there? What part of a leak would that guy be investigating? This is where my first instinct was, that's intimidation. There's a reason they brought these people in, lined them up essentially, sat them down, and had Baldwin and Rozzi come in. Like, okay, why are these people here? It makes no sense that those people would be there hours before they were even set to testify. Yes, Dietz, hi Dietz. Yeah. It does not add up, and you can't tell me that it makes sense. Because if everybody knew this hearing was going to happen, it was happening at 2. They were getting there early. They were getting there early because they had to talk to the judge in chambers. Doug Carter, Jerry Holman, Tony Liggett, none of those people needed to be there hours early because they weren't going in chambers to talk. Hey, Benya. Why would they get a lawyer but not know what was going on? See? That's exactly what I just said. That doesn't change my question. Tobe wasn't there because Tobe was back running in Carroll County. I think that they knew something was going on. I don't think that's the question. I think they knew something was going on, but nobody told them they were walking into a to be disqualified at that very moment. Nobody knew that. They didn't have anybody to bring. They didn't have anybody there. Now, if the defense team had brought Mitch and they had brought whatever, other lawyers were going to testify about being, thrown off of a case or, not being thrown off of a case for something that was similar or worse. If they had all of that, then I'd say, yeah, they absolutely knew what they were walking into. You can disagree. I don't care. You're welcome to stick around and disagree all you want to. Why'd they get a lawyer and not be allowed to have Hennessy? Yeah, he couldn't go in there. More importantly, why couldn't Richard Allen be there? Hey, cats. Maybe they have a leak. Right. I don't think they knew what they were walking into that. I think they knew they were walking in to have a conversation about it, but not that they were going to have a hearing to be disqualified. The email before court did say the prosecution wants the defense disqualified, but I agree they needed notice from the judge. Right, that's my point. So they had the idea that something like this was coming, but it wasn't set. The hearing wasn't set to be a disqualify them. She made a summary judgment to disqualify them, and that's where my issue falls. I'm not even saying they don't deserve to be disqualified. Even I can argue that back and forth on both sides. But I cannot let go of the fact that she did not go through the proper procedures to make this happen. So people want to skip ahead to that. Well, they deserved it, but it's like, yeah, okay. Even if they deserve it, you can't go about it the wrong way. Even if that's what the end result was going to be, fine, but do it the right way. They knew they were going to talk. Well, they knew they were going to talk about what the hearing was supposed to be about. That's what they asked for. They asked for, she set this hearing for the 19th and said, cease work, blah, blah, blah. McClellan said he wanted them disqualified. So now they're preparing, like, okay, is this what we're going in to talk about? Like, let's get these things, ready to go so we can go in there and talk about it if she's going to have. I think what they went in there to talk about was if she was going to even have a disqualification hearing. That's where I think that this was going. And the fact that they went in there and there was not even talk of it. It was just like walk or go. Oh, MK, thank you. MK's the GOAT. Yeah, just because the end result is the same doesn't mean that you can get there all shady like. And and that's another good point too. And I don't get how she ties Rozzi in with Baldwin and how she sums up both of their actions the same. Because I have a different argument for both. So for her to wrap them up into one like little bundle and make it the same thing doesn't make sense. Because Baldwin's office is the one that didn't have anything secure. So okay, so Baldwin. Then Baldwin goes into this hearing and he's the one who verbally withdraws. And then Rozzi says, I'll put something in writing later, but never does. So he never actually withdraws. So there's two totally separate situations, and then she makes them the same. So, Daniel, that's how I am. I really do, because, and I was saying this the other day, and I don't think people realize that by skipping these little steps, essentially now, like, no matter what happens in this case, unless he's acquitted, or all charges are dropped, I guess, no matter if he's found, how he's found guilty, there's an appeal, and she essentially set it up that way. So a lot of people think like we're mad at her because she wants, to put everything on Richard Allen, but it's almost like I'm more upset that every move she's making is making each path like, so normally you go down, okay, so here's my motion. If I rule this way, it probably can't be appealed. If I rule this way, it probably can. So I'm going to rule the way of less appeal. Then, but no, not her. She's like, I'm going to rule all the ways of appeal. And that's how I feel like she's screwing over the families, because they're going to be, not that he wouldn't be able to appeal anyway, but there's tons of appeals that happen all the time. They don't really affect the family. There's some that actually have legs, and those are the ones that the family ends up having to show up to. And this is going to be the rest of their life. That's where I'm frustrated, because I feel like no matter what, now we're screwed. What they need to do is bring in a different special judge. The special judge needs to hold a disqualification hearing based on the facts and make a decision whether Baldwin should be part of the case and whether Rozzi should be part of the case. That's what I think. I don't think they should just go, okay, Judge Gull's gone and new, old attorneys are back. I actually don't think it should. Yeah, there's going to be, it's a setup. So I think that they just need, or they should have had another judge come in from the get-go and do it, because she has absolute bias. There's no way people can think that she's not biased. Look at her court record. Look at what she's done with the case. It's a disaster from an appellate standpoint. Hi, ATS. So we can like Baldwin, not like Baldwin, like Rozzi, not like Rozzi. I think Richard Allen's innocent, think he's guilty. Like, really, none of that at this point even, that's not even my point. All right, let's get back to reading this. I don't even know where I was now. Let me take a drink first. I don't know. Yeah, I don't know. And if people think that she did everything she was supposed to, how do you push out that the Supreme Court is actually saying to look at it? Because if the Supreme Court thought it was just all bullshit, they wouldn't even put it on their docket. They wouldn't approve the application. The appellate attorneys are essentially saying, hey, Supreme Court, would you mind taking a look at this? And then they have to say, sorry, no, take it back. Or yes, we'll put it on our docket and we'll take a look at it. Both things now that have been filed to the Supreme Court, they have said, yes, we will take this application for this, emergency writ, or, they're taking it and saying, yes, we will look at it, which means that there's potential that something is wrong. If everything that's written here was just totally okay, the Supreme Court would say, sorry, no, here you go, have that back. We're not going to be doing it. Yeah, and the attorney general won't even defend her. Well, part of that's political, in my opinion. Like they don't want to be tied up in it. You know, they don't want to end up on the wrong side of this. No, I don't think so. I don't think so, Copper. I don't think the Supreme Court gives two shits about what's going on social media necessarily. Part of our Constitution, though, and when we go through what due process is, it does have to do with the perception from society of the judicial system. And you can't say that there's not a divided perception of what's happening in that courtroom. Yeah, and if she's done everything correctly, why can't we see it? Right. Well, I know, but maybe he thinks he's going to have to step in later. I don't know. I'm going to look more into cases where an attorney general's actually said no. Yes, I agree with that, ATS. Yeah, she had to. And here's the thing. This is why you knew that she knew something else was coming. So this is the same. Okay, so I'll turn it around and I'll say, here we go. People think Baldwin knew he screwed up because he hired an attorney. Okay, Judge Gull hired an attorney before this was filed with the Supreme Court. The only thing that was actually filed with the Supreme Court before was just to her to make a clear record, make a public clear record. And you don't have to make everything public. What you have to do is to put placeholders in there that cite the law on why you're choosing to not make that document public. So did she know she did something wrong? Is that why she hired an attorney? Because that's what we're saying about Baldwin. He knew because he hired an attorney. Well, then she knew because she hired one too. So it's just, I don't know. All right, let's go. I'm going to go back to reading. Then the court informed Rick's attorneys they had two options voluntarily. I think we read that. Attorneys Baldwin and Rozzi met with Rick to discuss the matter. Rick disagreed. We just talked about that, and that's why he should have been. And here's the thing, too. Everybody says, like, they could have gone. See, I gotta stop because everybody says, like, they could have gone into the courtroom and fought for their client. Well, why didn't she make it that they had to? Why was this even an option? It's, hey, the 19th, we're going to have a hearing on whether we're going to disqualify you as his attorneys or not. Come prepared. And then put it in the courtroom. No questions asked, nothing. And why? Okay, I'm going to leave that alone. Counsel has informed the court that they believe their withdrawal was involuntary and done under duress. Since their refusal to withdraw would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, and cast Rick, his attorneys, and the merits of his defense in a negative light. Such a public statement risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating an actual conflict for their continued representation. And I'm going to throw out a new thing here, or something else, because if she did do a summary judgment and believed that they had committed gross negligence, why didn't she file that on the court record? Where is that? Somebody show me that. From the 19th, that she filed it, even the 20th, whatever, right then, that she filed saying here's my summary judgment that they committed gross negligence. Not there. You won't find it. Good luck. Faced with this dilemma, Attorney Baldwin orally moved to withdraw his appearance, and Attorney Rozzi informed the trial court he would file a formal motion to withdraw his appearance at a later date. Attorney Rozzi did not withdraw. Now, here's the note. The court reporter declined to provide a transcript of the in-chambers proceeding, and the court did not rule on the relator's motion for the transcript. Relator is relying upon the recollection of Rick's attorneys memorialized shortly after the proceeding. Why is she declining to provide a transcript of this? Hey, Cal, somebody make that make sense. Why not just put it out there? She didn't do anything wrong, right? Everything she did was to benefit them and to help them so they weren't embarrassed and, it didn't wreck their reputations. Where is it? We have no summary judgment put into the court record, and now we're declining to provide a transcript of what happened in that room. Hey, Grace. Maybe a search warrant for all her devices. Drug test. She's gonna need another lawyer. The sad thing is that whatever reasons the judge decided to screw around in this case will be absolutely stupid in nature. Yeah, because there's no reason for it. Like if they did all these things that are really bad and she had all the rights to do everything that she did, where is it? It's like it should be very, very simple. We shouldn't even be here asking the question. We should be like, yeah, that was really bad. Maybe we don't agree that it was as bad as she thinks it was, but we don't even know what she's saying because she won't put it out there. There's no court record of it. It did. It got crazy really fast. I know, and that's why I can't leave, because now I'm stuck in this nightmare. The judge entered the courtroom, went on the record without Rick or his attorneys being present, and stated there was an unexpected turn of events and that Rick's lawyers had withdrawn from the case. The court concluded the hearing by noting that the state had some witnesses here that came earlier to have the hearing, but clearly this is outside of our control. Unexpected turn of events. I'm not really sure how it's unexpected because she thought they'd go into the courtroom and they'd fight. I don't know. I don't know what was unexpected because she didn't expect them to stay, and I don't know why Rozzi had to go anyway because we don't know what type of gross negligence she's claiming that he committed. Oh, Sleuthy's still here, isn't she? Sleuthy Goosey. She's been looking into her history. She's got some really good points on things that Judge Gull's done. In written order, the court noted that Rick's pretrial motions were still pending due to the court still reviewing the exhibits submitted by counsel. To continue pursuing Rick's trial strategy, counsel remained in the case as private counsel, but the court disqualified them. This is my other issue. How do you say what's changed since I disqualified you, but then also in turn say you withdrew? You either withdrew or I disqualified you. You can't have both. An unexpected event. Yep. It's about the knowledge he has. Judge had to call it unexpected to make it not look sketchy. Well, then, and most of us were talking about that like maybe Rozzi like was just pissed at what was happening with Baldwin, so that's why he left, and that's what she was talking about was unexpected, and that's why I want to hear. That's why the transcript is important. Good. So I know a couple of her history. The one where she let the dad who was essaying his girls or his stepdaughters basically let him go on probation. There was the other one that Sleuthy posted on Twitter about that there was like one of the attorneys that was representing the client like just never spoke essentially the entire trial. I was like, this is rich. And then that's a zealous, defense right there. Attorney Rozzi filed a notice indicating that Rick did not want him to withdraw as counsel. This notice informed the court that there were no circumstances under Rule 116 of the Indiana Rules of Professional Conduct which warrant the withdrawal of counsel, and that everything cited by the court as alleged quote-unquote gross negligence was the product of ethical lawyering in the best interest of the client's defense and mental and physical well-being. Now, I do believe that some of the things that are listed that she supposedly talked about are that. And I think that the biggest thing is going to come down to, it would come down to the leaks, and that it's not the first one. But that once again would fall on Baldwin. And we don't know if there's anything else because we don't have any court record of it. The notice also indicated that Rick was asserting his constitutional right to the counsel of his choice and wanted counsel to move forward with the representation of defendant Allen until a final disposition of this matter. That's pretty fair. Like, let's go legally and have a resolution here, and that these guys can stay my counsel until then. Finally, the notice indicated that Rick was prepared to go to trial on January 8th, 2024, and any continuance of the trial beyond that date would prejudice him. Hey, Jeanette. She's saving quite a lot because there's a character count, and whatever Gull's response is going to determine how much smoke she gets. Yeah, there is. It's the weirdest thing. You can only put like 4,800 characters in your writ of mandamus. I don't like that the judge said it was unexpected because I believed her. Oh, hold on, sorry. Because I believed her. Apparently, she had it all set up to ambush them and force a withdrawal, which is wrong. Right. And C. King, you are somebody who is like, what the attorneys did was probably really bad. But there's that portion that she can't do that part and make it even worse. I wanted to donate to help for missing women. The volunteers, apparently I didn't grasp the concept of volunteering. I missed that. I do what I want. I know I need that sign. And do what I want. So, and doesn't it matter? So he says he's going to withdraw. He'll put his in writing and he'll withdraw. And then he does talk to the client, and the client says, no, I don't want you to withdraw as my counsel. I want you to stay. Yeah, that's how I feel. ACB, it kills me how there's no problem that Richard Allen confessed 4 or 5 times was leaked to the world, which is extremely prejudicial, yet evidence photos that never got out to the public at large is. Well, and let's just backtrack on how many leaks there really have been, and how many people on YouTube talk about that they like to Matt Damanis. No, that made it worse, sweet dude. But how many people on YouTube talk about that oh yeah, I talk to Holman all the time. Or somebody came in here and they were like, this other YouTuber said that Holman told him that they're still looking into this, that, and the other, or whatever. And I'm like, why is Holman telling anybody on YouTube anything? Like, that's all. You can't do any of that. Yeah. Well, the whole leak is only since the gag order was put in place. That's what her leak would be. We got to know. I know. To have a character limit, they're like, nope, we don't want to read that much. Art of deduction, you were talking to Jerry Holman? You guys, you better not be telling you anything. It better be for you to be turning something into him and not him being like, oh yeah, Liggett told Carter this, that, and the other. You know what I mean? Like, he just doesn't need to be talking. You're like, I'm going back to the beginning. It's definitely Daniel Nations. You're my King of Kings. Okay. Where was I? Ethical lawyering in the best interest of his client's defense. And the notice also indicated that Rick was asserting his constitutional right to the counsel of his choice and wanted counsel to move forward with the representation of defendant Allen until a final disposition of this matter. So this has gone back and forth too, because when it's a public defender, your right to counsel of choice is pretty limited. But I did look up some case law before and some case precedent that there are times that it has gone higher, and the courts have determined that even though it was a public defender, that the defendant did have the right to counsel of their choice, even though it wasn't, because it typically states like it's only when it comes to private counsel, but they circumvented that anyway, and they went in and they signed out to be pro bono. So it is, I mean, now they're like, okay, now he has the counsel of his choice, and you can't really take that away, because if you're going to try to, to cite that it's okay to do it because we were public defenders, now you can't. We're private. Even if we're free, we're still private. Finally, the notice indicated that Rick was prepared to go to trial. We read that already. Rick, by counsel, also filed a motion seeking the special judge's recusal. The trial court ordered the clerk to remove Rick's filings from the record because attorney Rozzi was no longer counsel of record. The court also appointed 2 public defenders to represent Rick. And I said this when it very first went down, that Rozzi, because he had not submitted his written notice to withdraw, he was his attorney of record. There's no ifs, ands, or buts about it. He was his attorney of record. He was the one who has to file anything on Rick's behalf. There were no other attorneys. Attorney Baldwin filed a motion requesting the court to reconsider her order to remove he and Rozzi as Rick's counsel of record. In the motion, Attorney Baldwin argued that his oral motion to withdraw was involuntary. The court rules outlining the proper procedure to withdraw as counsel were not complied with. He and Attorney Rozzi were not disqualified and remained as counsel of record at the time they filed the motion on Rick's behalf for the judge's recusal. The court lost jurisdiction to take any further action in the case until the motion to recuse was resolved, which is typically how it's supposed to be, that nothing can happen in the case until that is taken care of. But she just said that they don't matter because Rozzi isn't an attorney here anymore. He doesn't go here, so it doesn't matter if he wants me to recuse myself. Even though it's on behalf of Richard Allen, who does still go there. Dun, dun, dun. Defense didn't hand out the Franks doc, right? Well, they filed it, and they filed it where it was public. And so that pissed her off because it had details in there that would go under the gag order, except for there's nothing that says that the gag order is to not talk about it publicly. So, I mean, some would say, yeah, that's a workaround, but it's still a legal workaround. So that's the problem. She needs to be able to say why she's sealing that document. And even when she removes it. So I'll give you just a basic example. I submit a search warrant for TikTok, but I don't want you guys to know what I'm looking for, and I don't want you guys to see it. So I request to have that part sealed. But you guys can know that I requested the search warrant. You're just not going to know what I was looking for or what I found, right? So I submit that to the judge. The judge approves it. They seal it. And then in the order on the court record, it would say, like, search warrant for TikTok sealed and pursuant to California code, blah, 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 whatever it is, whatever the law is here, or whatever the law is wherever it is. That kind of, like, it becomes like a placeholder. And so the court record still stays fluid, but you know that that's sealed, and you know legally why that's sealed. Does that make sense? So this Franks motion was not required. It does not fall under what the gag order required. So it did not need to be filed as sealed. Now, should they have filed it as sealed or not? That's a different conversation. But it was not court required to be sealed. Then she removes the Franks memorandum, and she doesn't put anything in there saying, this document is now sealed pursuant to Indiana, blah, 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 blah. Does that make sense? Awesome. Hi, honey. But it has to go. You have to still keep it clean. So we know that there's the Franks memorandum that's filed, but we know that the judge is determined to have it sealed because of this law. Or this, you know what I'm saying? Does that make sense? If you can't just go, hey, I'm just going to take that off there because I don't want it there anymore. Correct. Makes me chuckle. That's a gag order. You're ordered to gag. Code, blah, 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 blah. I need a coffee. 1960s, like, I need a coffee. I'm probably going to need a new Dr. Pepper. I can't believe she turned to the prosecutor. This is the other thing. The prosecutor doesn't have any freaking say in this. The prosecutor doesn't get to choose who gets to represent the defendant. His opinion means shit. Don't ask him. I gotta stop talking to you guys because I totally lose where I'm at, and then I end up reading the same thing like 15 times. Reconsider. Did I already read this? Attorney Baldwin filed a motion requesting the court reconsider her order to remove he and Rozzi as Rick's counsel of record. In the motion, Attorney Baldwin argued that his oral motion to withdraw was involuntary. The court rules outlining the proper procedures to withdraw as counsel were not complied with. He and Attorney Rozzi were not disqualified. That's the thing. They weren't. They were not disqualified and remained as counsel of record at the time they filed the motion on Rick's behalf for the judge's recusal. The court lost jurisdiction to take any further action in the case until that motion to recuse was resolved. We read that. The day before a hearing scheduled on October 31st, 2023, attorneys Baldwin and Rozzi entered their appearances as Allen's retained counsel. In their appearances, Baldwin and Rozzi reasserted their belief that they were improperly removed as counsel of record and that they were now entering their appearances as private counsel in order to protect Allen's constitutional rights to a fair and speedy trial and to honor his 4th, 5th, and 6th Amendment rights. On October 31st, a hearing was held. Attorney Baldwin stated that Rick had asked them to represent him, so they re-entered their appearance. The court asked what had changed in the 12 days since they had chosen to withdraw rather than be removed. Attorney Rozzi argued that their withdrawal as counsel was involuntary. So as to avoid prejudicing Allen's defense by allowing the court to disqualify them, he also argued that Rick had a constitutional right to counsel of his choice. He had asserted that right, and the court had no authority to remove his counsel without due process. The state indicated it agreed with the court that Rick's counsel were grossly negligent. The state reiterated the examples of negligence that the court had noted during the in-chambers hearing. The court acknowledged that Rick had chosen attorneys Baldwin and Rozzi as counsel, but refused to recognize them as his counsel, stating, "I have grave concerns, Mr. Allen, about the representation of you. The previous findings by this court of their gross negligence. Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, because I know what you want. You've indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns that I've had with the gross negligence that I have found." They withdrew rather than being found grossly negligent and be removed. "I can't do it, sir. I just can't. I cannot allow that." See, this is it. So which one is it? You withdrew, or I found you grossly negligent? You can't have both. And if she found them grossly negligent, where did she find it? Because there's no documentation showing that she did. And I know she can't be stupid. I mean, she knows that there's the procedures that she has to go through. She can't just be like, "Nope, I'm sorry, I find them grossly negligent." Okay, how? When? Why? Yeah, it doesn't work that way. So fine, find them grossly negligent, but do it in the proper procedures. Thereafter, the new attorneys requested a continuance of the January 2024 trial. The court granted the request and set an October 24. Another weird coincidence in this case. Everything's on Halloween. October 2024 trial date, noting that counsel had not yet received the discovery and were unable to estimate when they would be ready for trial. The new attorneys admitted they could not tell the court with any certainty that they would be ready in October. The court also noted had not completed review of the exhibits related to the Franks motion, and that once new counsel had time to review discovery and the pleadings, they could either adopt those pleadings or make their own. So the grounds for their writ. The trial court lacked any authority to remove Rick's entire defense team over his objection and based on summary finding of gross negligence. Original actions provide extraordinary remedies, and accordingly, writs of mandamus and prohibition will be issued only where the trial court has an absolute duty to act or refrain from acting. And there's a lot of case law cited here, so if you're somebody who enjoys looking at case law, they put a lot in here. The court routinely relies on its original jurisdiction to address claims that attorneys have inappropriately been disqualified or that they could have been disqualified, and then cites the next case. Here, trial court has an absolute duty to reinstate attorneys Rozzi and Baldwin, and the remedy on appeal is non-existent. The Sixth Amendment to the Constitution provides, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The right to counsel embraces not only the assistance of counsel, but also the reasonable opportunity to secure counsel of one's own choice. More case law. The attorney-client relationship, once established, is inviolate, and should not be severed or subject to unwarranted interference. More case law. The attorney-client relationship is afforded the same venerable protections whether the lawyer is a public defender acting pro bono or privately retained. More case law. Indiana recognizes only two narrowly circumscribed situations where a trial court may sever the attorney-client relationship against the client's wishes. One, when the lawyer is not a member of the state bar. Two, the lawyer has an actual conflict of interest that will obstruct his ability to provide effective representation. No Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection, based on the judge's subjective belief the lawyer is negligent or even grossly negligent. And courts across the country regularly issue extraordinary writs in criminal cases to reinstate defense attorneys who have been kicked off cases for conduct the trial court found upsetting or negligent. A whole bunch of case law. When a court believes it possesses objective evidence to support a lawyer's removal, it should clearly articulate that evidence on the record and exhaust other possible remedies before resorting to the removal of counsel, such as disciplinary referral or contempt proceedings. More case law. Removal, if ever considered by a judge, should be an absolute last resort, and the removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice and an opportunity to be heard on why the attorney-client relationship should be severed. Here, the judge acted to terminate the attorney-client relationship when she had an absolute duty to refrain from doing so. This court should mandate attorneys Rozzi and Baldwin be immediately reinstated. Attorneys Baldwin and Rozzi were active members of and in good standing with the Indiana Bar, and there is no conflict of interest even alleged between Rick and his attorneys. The inquiry should end there. But attorneys Baldwin and Rozzi were removed because the trial court disagreed with their conduct. The judge made a sua sponte summary finding in chambers of gross negligence after the state raised the issue of disqualifying them. It is entirely unclear from the record what the court found was grossly negligent. The record only includes Attorney Rozzi's recollection of the acts mentioned by the court because Rick has been unable to obtain a transcript of the in-chambers hearing or proceeding. Nevertheless, the judge's subjective allegations of gross negligence fall into two categories. One, a mere disagreement with zealous defense tactics, or two, concerns about the unintended release of evidence which objectively had no effect on the lawyer's ongoing effective representation of Rick. A Sixth Amendment interference with counsel claim is at its zenith when a trial court dismisses a lawyer because it disagrees with competent advocacy. More case law. That is precisely what has occurred here. Once attorneys Rozzi and Baldwin were appointed and became Rick's counsel, the court lacked any authority to obstruct and sever that relationship. If the court found their conduct upsetting or negligent, it should have clearly articulated the evidence on the record and exhausted other possible remedies before removing them from the case, such as censure. I don't even know what that actually is. Let me look that up. Disciplinary referral or contempt proceedings. I want to know what that means. Express severe disapproval, especially in a formal statement. Okay. Or contempt proceedings. She had an absolute duty to refrain from obstructing and severing the relationship, especially where attorneys Baldwin and Rozzi suggested a remedy in the event the court was considering removal. This court should grant emergency relief and reinstate attorneys Rozzi and Baldwin, but reinstatement of Rick's counsel of choice is not sufficient to remedy the violation here. Rick was pursuing a speedy trial and a third-party guilty strategy. He intended to file a speedy trial request in early November, but the judge kicked them off the case, rejected their appearance, and struck their pleadings. This court is the only court in the state that can order a speedy trial date. If it does not seize this opportunity now, it will be lost. It will be forever be lost. There is no post-judgment remedy available. The new lawyers have already indicated they will not be prepared for a speedy trial. A new judge also should be appointed to avoid the appearance of bias that will otherwise permeate these proceedings. A judge shall disqualify herself in any proceeding in which the judge's impartiality might reasonably be questioned, including circumstances where the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of facts that are in dispute in the proceeding. The commentary to this canon provides that under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. Here, the judge summarily found that counsel was grossly negligent and publicly proclaimed that she has grave concerns about their representation. The judge also emphatically stated she could not allow them to remain as Rick's counsel, given her concerns about their representation. For many Hoosiers, this case marks the first time they have followed the workings of an Indiana court. Yet for all rulings going forward, the public will question the judge's impartiality. To restore the public's trust in the integrity of the judicial process in this high-profile case, a new special judge should be appointed. To ensure that going forward, Richard Allen receives his fundamental right to counsel, a writ of mandamus is appropriate to reinstate attorneys Baldwin and Rozzi as court-appointed counsel, to set a trial date within 70 days of the issuance of this writ, and remove the special judge and appoint a new one. And then you just have, here's your verified word count. It contains fewer than 4,200 words. And that's just your filings. That's who it got sent to. Dun, dun, dun. All right, let's see what you guys think. Mic drop. Right. Can't be any of her Facebook friends. I believe the only way to make this case fair again is if everyone goes. The lawyers, the judge, the prosecutor, they appoint a new judge, special prosecutor, and new lawyers. But then the problem with that is Richard Allen's right to a speedy trial. That would be the issue with that, because I agree. I was like, everybody just needs to go. Let's just start over. But if he does want to put in, that he wants a speedy trial, then you got to have the same attorneys. That means that Gull has to go. And it's his rights are more important than Gull's. I mean, I shouldn't say his rights are more important. That's not the right way to word that, but should be looked at a little bit more in this circumstance because he is the defendant. Right, Rexy? I know, it's like, come on. If the defense doesn't put on that he's absolutely innocent, like the judge is doing a good enough job with Nick McClelland, they would have made a show out of the prosecution. Not so slick Nick couldn't have that. Well, yeah, and he finally brought in, I thought it was the 31st, but apparently it was the 19th, that he finally brought in a special prosecutor, which should have been from the beginning. I hope he's innocent if he's going to get off, because that's where I'm at too. If this guy actually did it, then I don't know how a jury's going to find him guilty. They better hope that they have a lot more than what we know of. Hi, Delana. Oh yeah, I think so too. He doesn't have the background to be able to prosecute a case like this. This is why he needed a special prosecutor. What do you think? $1 million for each year of violating his rights and subjecting him to inhumane. Oh gosh, could you imagine the civil suit that would come out of this? Yeah, the same lawyer that is Facebook friends with the judge is the one that's fresh back from suspension. And the other one is the one that did a TV interview talking about how the bullet is really good evidence, and talking about Richard Allen's guilt. You can't make this shit up. Yeah, the prosecution basically got to choose his defense team. Hi, Hybrid Pisces. Hey, Teresa. It's not just the judge. They need a new prosecutor too, in my opinion. Otherwise, he won't get a fair trial. And so that's one of the other things I was thinking about with the attorney general is maybe he doesn't want to get involved because if he has to take over the case for some reason, if his office has to take over the case, then what bias does that put him in? I don't know. That's why I said I got to look more into that because I'm really interested to know why the attorney general would just say no to her. I mean, we can all speculate. I find Gull grossly negligent. Malicious intent. If you were RA and the judge ruled against your right to defense, how would you feel and what legal steps would you take? I would, if I was adamant that these were the guys that I wanted as my defense attorneys, I would do exactly what's happening right now. And thank gosh there is these attorneys that are willing to step in and file this stuff because this is what I would do if I really did. But you know, when I was talking to Chris Welch the other night, the defense attorney that was on with me, he made a really good point too, that, you know, if Richard Allen gets these attorneys back and he loses, then does he flip and say, you know, they really screwed me up and, you know, I was a mess and I shouldn't have stayed with them. And I don't know, it's like a catch-22 almost. But for me, if I believe that they are really the right people for me, then I would fight. I wouldn't. And I would want a speedy trial. And then how do you have effective counsel? There's no way he would have any effective counsel if he says, yeah, I want to invoke a speedy trial. And then they go to trial and these attorneys aren't prepared. Then, so he's screwed. He has to screw himself either way. Well, yeah, that's what I said. We can all guess. But I want to look into like other cases where that would have happened and what their reasoning for saying no would have been. He can reassert his right to a speedy trial at any time. Even if he's waived it, he can reassert it. And then there's a certain amount of days from that point on that he has to have a trial. He could do it with his new attorneys. He could do it with his old attorneys. He could change that. Everyone says the same. Innocent people have been convicted before. Stephen Avery was one who had a rock-solid alibi. Convicted of rape, did nearly 20 years before being cleared. Do you think he's innocent now? Do you think they railroaded him again because he was such a jerk face? Pages and pages. There was no ill effects or gain to RA's case, so it can't be gross negligence. There was no effect to any potential jurors. That's how I feel about it. And I said from the beginning that it's not like there was like evidence tampering. The pictures, they're just pictures. And like I said, I know that people get really offended when I say that, but they're not like the actual evidence. Like nobody's, like the pictures aren't destroyed. They're not gone. Like they're still going to go to court. They're still going to show them. They're going to be fine. Like nothing's changed at all. And when they say like it's going to tamper with like a jury pool, we have states, and I know it's not Indiana, but there are states in this country that will give you all the photos before it even goes to trial because they do not feel that it will affect a trial because it doesn't matter. And that's their laws. So it scares me he's facing the death penalty and his whole process has been super messy. 6 wrongful convictions in Elkhart, Indiana. Look up the police gang called the Wolverine. Ooh. Well, that's the thing. He's not probably going to be facing the death penalty because the 2 attorneys she put on there aren't death penalty certified. Neither one of them can actually defend him then. So there's something wonky with that. It doesn't. Same here, my King of Kings. Like I'm the same. Right? It's just a leak of a couple of pictures. I get the content is really bad, so it like infuriates people, but it's not. It's just not. It's not that big of a deal, which is why I thought it was so weird that Murder Sheet was like adamant that they were gonna like. The biggest thing that could happen is they could be removed from the case. And then like the day of, they're like, yeah, it was like foreboding that was going to be the conclusion at the end of the day. I'm like, why would you even go there? Why would you think that was going to be the end result? That's just a weird thing to me. They're willing to take time and money from their own firms to fight for Richard Allen. That speaks volumes to me. Well, if you go to the other side of that, Amber, people are going to say, well, of course they want to. It's the biggest case of their career. You know how much money they're going to get afterward for interviews and book deals, and I don't know the guys, so it's like you can't really. I mean, fighting about that it doesn't. What are you going to do? We don't know them. We don't know what's in their heart. Look at how much was out in Murdoch, yet they were all still able to find jurors in a very small county, just like this county. Well, ironically, they're probably going to have a new trial in Murdoch. It's because of the jury and the court clerk. I don't know. I don't know what their latest one was. The last one I listened to was the court date on the 31st. Hey, Ruckus. He still deserves a fair trial, and there were photo leaks going back years before RA was ever even arrested. So where did those leaks come from? So I've been doing like a lot of digging into this freaking leak shit, and I'm telling you, there's something really wonky about it. There's something really wonky about it. Those attorneys were born for this moment. People only notice it when it's a case like this where everyone knows about it. And I guarantee you too, Princess Mariposa, how many of those smaller cases that we don't know about, how many of those cases do you think that the attorneys got removed? Hey, Jeannie. Did OJ's? I don't think they had to do it for free. He had quite a bit of money. I think he was able to pay all of them. Well, Robert was his friend, so I don't know how much he actually paid him. There's something wonky. Okay, so like I said, there was a whole bunch of filings, but the ones that I found that were like the most important ones. Hold on. Do I have this in? I think I have this all in one. This is the record of all the proceedings, I think. Let me just double check that I pulled up the right one. I think it might be this one that I want to look at. Nope, not that one. Nope, not that one. So here's the motion for the transcript. That's pretty straightforward. Where is the one that I want, though? I think it might be this one. This one. Can you guys see? You guys can hardly see that, huh? Make sure you guys can see that. They need to get a jury from Panama. Jay Turner, I know. I'm like, he really has. Like, how does that guy get involved with every single leak happening? I guess he just talks to the right people. You searched 67 files for that. All right. So let's see. So they have in here the court proceedings from the 31st. So if we want to hear exactly what was said, it's here. Is this the 31st, or this one might be the 19th? Hold on. Now it's so big I can't see it, but you guys, if I make it smaller. Transcript of the hearing on the 19th, the motion to reconsider, the request for the audio from the chambers meeting, the defense counsel's appearance, the transcript of the hearing held on October 31st. This is the one that I want to show you guys. Page 33, I guess it is. There's so much more transparency from the defense team to the public, and I think that might be one of the reasons they do get a little pissed off. But here we have Mitch Westerman, Mr. Leaky, who went in and took the pics from Baldwin's office. This is his affidavit that I really wanted to see, and then I was kind of let down because it's not very much. But He essentially says, comes now Mitchell Westerman, being first duly sworn under oath, and states that the following information is within his personal knowledge and is true to the best of his knowledge. 1. I was in attorney Andrew Baldwin's office building waiting to visit with Andrew. He was in his office either meeting with a client or on a telephone call with the door closed. I went into the conference room to wait. I observed printed copies of photo evidence on the conference room table. I took pictures of a few of them. Andrew Baldwin did not give me permission to take the photos of the printed copies. He was not present, and he did not have any knowledge that I took pictures of the evidence photos. I am freely and voluntarily typing and signing this affidavit on my own accord because it is the truth. That's it. I'm like, that's it. You're not going to put in there that you sent it out to people, who you send it to. So we can't even get a firm answer on that he's the one who sent it to Robert Fortson. Isn't that interesting? Okay, Dietz. Yeah, you got way fun stuff to go do. Once they found his original tip, they called him in to interview him, and he reaffirmed he was there that day and what he was wearing. You know, when Winnicki lays it out like this, the case against Gull sounds devastating. How can she defend her decisions that have brought us to this disastrous point in the case? That's my question. I don't even know how she could defend it at this point. Because like, how do you hide the record? Why don't you have any of this? Right. We don't know. We that's why it's tough, because we are told narratives and we don't know which one's actually the truth. Or is everybody telling us a partial truth? And then the story changes. It's so frustrating. And then it becomes like, well, it's not a big deal now because it's over and it's already done and everybody deleted everything. But I'm like, is it though? Wayek, and if he's guilty of this, then he's also linked to a nationwide white power terrorist group, and maybe that's exactly what he's trying to tell his attorneys without naming them. Hold on, did you make another comment up here? Because you said and. I love these attorneys. I think they are great for Richard Allen. This whole case is messy, which is so sad. Libby and Abby deserve justice. I just struggle so much, because if he's guilty, then we're going to end up, we could very well end up seeing him walk free. And then if he's innocent, we could very well end up finding him guilty. It's such a struggle because nothing is clear. And why do they keep trying to push out the trial? I feel like pushing the trial till the end of next year. And of course, it's obviously because the new attorneys need time to go through discovery, but the purpose of like all of this happening and moving them off the case, what's going to happen? What are the investigators going to be doing for the next year? Are they going to find all the missing discovery that was requested the day before the photos were leaked? That's a great question. Great question. I have so many questions about the leak stuff. Yep, Bob and Allie are going to be doing a live later. I think if somebody can tell me the time. I think it's like 5 o'clock my time, 8 o'clock. Don't quote me on that. So Mitch supposedly admitted what he did, and Baldwin accepted responsibility for allowing him into his office. So what's being hidden by sealing Mitch's deposition, right? And so I was expecting digital. I was expecting that it was going to have like something like huge, but nope, it's gone too. You can't find that on the record either. It's not there. If Allen is guilty, then Indiana has only made it worse by making it just about impossible to convict him fairly. He would likely win any appeal. I think he would absolutely win an appeal to get a new trial at this point. Without removing the judge, I don't see how he couldn't get a new trial. If Allen is innocent, he will be Hillary. If he's guilty, his conviction sticks. They will never pay him what an innocent man would deserve in a civil trial. Hey, jujitsu. Let me see if there's anything else in here that I want to show you guys. Oh, here's Attorney Baldwin's affidavit. Attorney Baldwin is one of only 4 Indiana attorneys certified in criminal trial specialists by the National Board of Trial Advocacy, authorized under Indiana Rule of Professional Conduct. Attorney Baldwin has represented thousands of clients all over the state of Indiana. During his career, which has spanned nearly 30 years, many of his clients have been accused of murder, rape, robbery, burglary, and various other serious violations. Additionally, he estimates he has represented clients in more than 125 jury trials. On multiple occasions, Attorney Baldwin has been asked to teach trial techniques to lawyers, young and old, at the Indiana Public Defender Council annual week-long Trial Practice Institute. In the past 2.5 years alone, Attorney Baldwin has represented at least 5 clients charged with murder. Attorney Baldwin has never been disciplined in any way as a lawyer during his nearly 30-year career. Attorney Rozzi has a BS in criminal justice and an MS in criminology and was previously employed by the Indiana Department of Corrections, Marion County Pretrial Service Agency, and also worked as a private investigator investigating both criminal and civil matters before obtaining his law degree. Gosh. Attorney Rozzi has over 20 years of criminal trial experience handling thousands of cases, including 8 murder cases, 3 of which have been tried by jurors. Attorney Rozzi has also tried various other major felony cases, including but not limited to cases involving child molest, attempted murder, robbery, burglary charges. Attorney Rozzi was previously certified to handle death penalty cases. Attorney Rozzi practices regularly in Carroll County, where these crimes occurred, and in surrounding counties, and is very familiar with the geographic area near which these crimes were committed. Attorney Rozzi is the designated Cass County representative for character and fitness interviews associated with newly sworn attorneys. That's interesting. This appointment came by the way of recommendation from the Honorable Judge Lisa Swaim, Cass County Superior Court. Attorney Rozzi has never been disciplined in any way as a lawyer during his 20-plus year career. Richard Allen desires Attorney Baldwin and Attorney Rozzi to continue to represent him. He's asserted this in writing and orally in open court as recently as October 31st. On August 17th, 2023, Max Baker and Attorney Rozzi visited Richard Allen at the Westville Correctional Facility. During that visit, Attorney Rozzi tendered a motion for early trial to the client, Richard Allen. Attorney Rozzi further explained to Richard Allen the desire of his attorneys to use the motion to firm up the January 8th, 2024 jury trial setting by filing the motion sometime during the early portion of November 2023. Richard Allen signed the motion, and Attorney Rozzi maintained the original motion undated in his office and continues to possess the signed motion. That's interesting. So they did have it from before, supposedly since August. On October 4th, 2023, Prosecutor McClelland, Attorney Baldwin, Judge Gull, and Attorney Rozzi participated in a phone conference regarding motions requests that were filed by Defendant Allen on or about October 2nd, including defendant's motion for discovery deadline. During this phone conference, Judge Gull commented that she assumed the defense request for a discovery deadline was intended to support a request to continue the January 2024 trial date. Attorney Baldwin then communicated to Judge Gull and Prosecutor McClelland that the defense was not interested in a continuance and, in fact, intended on going to trial on January 8th, 2024. This is on October 4th. You guys know that falls right into the timeline of all of this leak shit. The parties participated in a telephone conference with the court on October 10th, 2023 to discuss the matter of Westerman surreptitiously taking photos of crime scene photos and deposition exhibits prepared by the defense. During this phone conference, the state suggested the disqualification of the defense counsel might be appropriate. In response, and during the same phone call, Judge Gull then indicated to the parties that she was leaning toward disqualification, but mentioned no rationale for her comments. That she was leaning towards disqualification. on the phone call on October 10th, which, hello, then October 11th, Richard Allen writes the letter, and then October 12th, she tells them they can't work on the case anymore. But she doesn't actually tell them that she's going to have a disqualification hearing. Why not just tell them you're going to have it then? This is really interesting. I keep using that word because this timing is just so bizarre. She thought they were that they were putting in the motion for the discovery deadline because they were going to request a continuance, and they said no. We have no interest in that. On October 4th. The same day that Snee said originally that he had gotten the photos. He said he got them Wednesday. He changed it yesterday that he got them Thursday. But originally, he always said he got them Wednesday. He said he got them on Wednesday, October 4th. All right, let's see what else is in here. Oh, here you go. Here's your motion for an early trial. Let's see what else. That's just certifications of filings, so on and so forth. Ah, shiznit. That's the proposed. That's the proposed. This is the verified petition for the writ. It essentially goes over the exact same thing that the brief goes over, just written differently because of that document that it needed to be written that way. The record of proceedings, we just did that one. Record of proceedings. Let me see if there's anything in this one. Because I think this is the one that just has the Frank's motion. And so it makes it really long. Chronological case summary, order on initial hearing, letter to the court from Allen, the press release, protective order, the emergency motion to modify the safekeeping order. We have all these. Or 414 order. I don't know what that one is. Indiana tort claim notice, the Frank's memorandum, the verified motion for immediate transfer of custody, letter to court from attorney Rozzi. Is this the same one we got before? Because it looks like maybe they just attached the same one. And then here's the record, that volume 2. Yeah, that's the first one. We already had that one. Affidavit from attorneys Andrew, Baldwin, and Red Road. We just read that. Yeah. All right. I think there you have it. That's essentially. Which one's different? This one's different? All right. Well, we can read through it because when I read through them, it seemed that they're fairly the same. They're requesting the same thing. Hey, Sniper. Let's see what Sniper said. Flat out, the state knows their case against RA is beyond weak, at best fabricated at worst, and the prosecution was absolutely getting out-lawyered and are terrified to go ahead to trial. Isn't that timing? The timing of all of this, come on. How many coincidences are there? How many coincidences do there have to be before people start questioning it? This is, I already read volume 2. That's this one. Volume 2 with the affidavit and all that stuff. Volume 1, this is what you're saying is different, Sleuthy? I think this is the same. This is the same. Let me pull it up. Let's see if I can find it. I've saved like 1,000 photos since then. That's the order. Here's the petition. Oh, record of proceedings. That's what I want. I don't want that. This one. Hold on, I have too much shit open. It's not wanting to move. Let me close some stuff. So everything's going wonky. Yeah, because I think they just added in the volume 2 part. Come on. Let me see what else I can get rid of. Sorry, guys. Give me a second. It does not. I just have so much open. It's like pissed off at me. Okay. Let's wait for it to load. The gag order. No, this is. It might be different. It's the press. This has got the press release, the protective order. Some of it looks like it might be the same, but then some of it is different. All right. It shouldn't be too much to kind of scroll through real quick, so we'll see if there's anything important, because I'm not going to go through the Frank's motion, which is the 136 pages of this document anyway. So this is just the, it's just my case, my case, my case. 613. Yeah, we don't need any of that. I haven't gone through this one because I thought it was the same, so that I don't know exactly where I'm going on this one. I went through the other one because I thought it was the new one. This is November 3rd. That's him requesting for him to be moved. That's him asking for public defenders. That's the press release. What date is this one? Is this the gag order? No, this is not the gag order. That's the discovery order. Emergency motion to modify the safekeeping order. We know that one. That's when they're asking for him to be moved. There's the pictures that they put in there when they asked. I'm just looking to see if there's anything new. If anything pops out at you. Memorandum in support of the accused motion for the Franks hearing. This is the Franks hearing. I don't want all that. Let's go down. Okay, then we have, what did you say was new? Page 214? Okay, I'm almost there anyway. Verified motion for immediate transfer of custody. Exhibit K. This is October 12th. Okay, dear Judge Gull, in the wake of the recent circumstances surrounding the distribution of crime scene photos in this case, Andrew and I thought it appropriate to communicate to the court in writing our version of the events and general thoughts regarding Nick's comments, that he believed disqualification may be the appropriate remedy here. Naturally, those are strong words and warrant some. You guys cannot see this. Let me blow it up. Hold on. Okay, so in the wake of the recent circumstances surrounding the distribution of crime scene photos in this case, Andrew and I thought it appropriate to communicate to the court in writing our version of the events and general thoughts regarding Nick's comments, that he believed disqualification may be the appropriate remedy here. Naturally, those are strong words and warrant some response from the defense. Therefore, we thought it appropriate to provide some context regarding what has occurred here and the circumstances arising therefrom. Our thoughts are as follows. Facts. Andy has offices in 3 separate locations, but primarily works out of his Franklin office. In the far back of his office building, Andy has a personal office which sits next to his conference room. Throughout this case, we, the defense, has utilized the conference room as our home base in terms of storing diagrams, photographs, and other exhibits that are involved in this case. We have also used the conference room for our defense team meetings and to generally review discovery. This includes searching through the 20 or more hard drives that we have been provided by the state, various thumb drives, and other discovery documentation. I would estimate that 90% of the discovery and related materials in this case are generally located in Andy's office. Andy has a friend by the name of Mitch Westerman. Mitch has a law degree from Valparaiso and at one point in the past worked as an employee at Andy's firm. Mitch is also Andy's personal friend. It is probably not anymore. It is my understanding that Mitch had a girlfriend in the Franklin area and therefore would routinely stop by the office when he visited his girlfriend. Andy communicated to me that Mitch was a fairly skilled strategist and that he would sometimes communicate ideas and circumstances with Mitch to get his feedback. Andy reported that he did this on occasion in this case. At no time did Andy ever authorize Mitch to duplicate or take physical possession of any exhibits or documentation in this case. During the week of October 2nd, the defense became aware of a gentleman in Texas who had claimed that crime scene photos had been leaked and that Andy was the party who leaked the photos. Naturally, this called for some immediate disclosure. Andy and I discussed the matter and believed that it was important to communicate our concerns with the prosecutor and court. This disclosure was accomplished through emails you received from us last week. On Monday, October 9th, 2023, Mitch Westerman showed up at Andy's office and asked for a few minutes of Andy's time. Andy reports that during the conversation, Mitch acknowledged that he had made a mistake and in fact took it upon himself to access Andy's conference room and photograph some exhibits that he discovered laying on the table. We believe this occurred back in August when we were preparing for the first round of depositions. In fact, Nick later confirmed that they, the prosecution, believes that the docs possessed by Westerman are the same or similar to the exhibits that were offered up by us during depositions. Westerman then reported to Andy that he shared these images with his military friend who is not associated with the defense in any manner. This man then apparently distributed them to a man in Texas. The man in Texas is the same individual that was accusing Andy of intentionally leaking these documents. So Mark just says straight up, like Andy leaked them? Okay. Mitch Westerman then apologized to Andy for what he had done and indicated that he would do whatever was necessary to make things right, including talking to the police. This conversation between Andy and Mitch Westerman occurred around 4 p.m. on Monday, October 9th at 4:48 p.m. Andy shared with me what had occurred at his office in Franklin via email. I did not see the email until the morning of October 10th, as I attended a school board meeting on Monday afternoon at 5 p.m. and thereafter spent some time with my kids. The next morning, Tuesday, October 10th, while at work, I discovered the email. I then immediately communicated with Andy. We agreed that we needed to disclose these facts to Nick immediately, which we did. This occurred by way of a phone call with Nick just minutes before we spoke with you yesterday afternoon. As a follow-up matter, we have tried to encourage Mr. Westerman to make himself available to the police for questioning either alone or through a lawyer. We've learned he has sought out legal representation. We spoke with his attorney, who refrained from any substantive comment regarding the matter. The same attorney then communicated to us a few hours later that he was getting out of the matter and was referring Mr. Westerman to alternative counsel. Understanding that there was some obvious barriers here, we are attempting to try and convince Mr. Westerman that he should come forward and acknowledge his wrongdoing. It is also worth nothing. I'm assuming that might be noting, but okay, that I, Attorney Rozzi, have made arrangements to provide a formal statement to Trooper Ben Rector today, October 12th, at the state police post in Peru. Attorney Baldwin has also reached out to Trooper Rector to make arrangements to make a statement regarding the matter. He currently awaits the trooper's return call. I have also disclosed the issue to Mr. Allen himself and communicated various other matters involving the case to Mr. Allen. Mr. Allen communicated to me that he desired that we, Attorney Baldwin and myself, continue with our representation of him. I have included herewith a letter confirming this fact. These are the facts as I understand them at this time. Number 2, what occurred here? Our analysis of the situation is that Mitch Westerman committed a crime by exerting unauthorized control over the property of another with the intent to deprive the other person, Andy Baldwin, of any part of its value or use. This is theft, which Westerman's criminal acts were then aggravated by his further distribution of the stolen images. Is this a violation of the gag order? Well, I got to see what you guys are saying. It's time for journalism, folks. It's time for journalism. Yeah, he's leaking all over. He's got a leaky problem. Let's ask Nick if he's ready to go to trial. He'd say no. Delphi is political move case. This explains corruption. Plus, how many new 2 children murder were released, and one of them was POI in Delphi. His name is Jimmy Duval. Nope, not thrown out yet. But the new attorneys can decide that they don't want to further pursue it. And with friends like that, they're allowed to consult. Yeah, they are. They can consult. And I guarantee if we actually pull up who it pertains to, that's what I was saying earlier. It'd be interesting to see who she lines out that they're allowed to disclose things to. I think so too, Sniper, but I feel like not everybody sees it. Not everybody sees that it should be terrifying and piss off people when it comes to our constitutional rights. And even the people who just want to go ahead and say, like, it's about Abby and Libby and it's about the families, like blowing up his constitutional rights really royally screws over Abby and Libby's families. They just don't, they're not there. They don't get that far with it. It's just like, nope, these guys are bad. They're out. Good deal. Let's move on. I think so. I haven't really kept track of him, but I know when he was very first appointed to take on this case, he definitely did not have anything like this. Have you seen Michelle A? No, I haven't seen Michelle A. I worked for a weekly local publication. I had more journalistic ethics than most actual journalists covering this. There's so many different types of journalists now. It's almost like there's mainstream media is so different than it used to be. I'm going to grab a drink really quick so I can keep reading. Hold on. God is always with you today. It's about money, power, and vendetta. Well, isn't that in? I wonder what Odinistic runes match up with money, power, and vendetta. Right, hybrid? I know. Okay. Number 3. Is this a violation of the gag order? The order on the judgment of the court, gag order dated December 1st, 2022, prohibits the parties from disseminating information or releasing any extrajudicial statements by means of public communication. In this circumstance, Mr. Westerman engaged in the criminal act of theft and thereafter took it upon himself to further distribute the stolen images. At no time did anyone from the defense team ever disseminate information by means of public communication, i.e. the media. In fact, there was never any specific intent on the part of the defense to disseminate the information in any manner. This does not amount to a violation of the gag order. Money is fihu means fee cattle inherited property. Last I heard, he was working for an ethics committee. Oh, Michelle After Dark. Oh, that's what you were saying. Did I see Michelle After Dark? Yes, from yesterday. Shoot, I don't know if I saw it yesterday. I'll go watch it though. I love Michelle After Dark. I try to keep up on all of them, so I may have watched it, but it was a busy weekend, so I'll double check it though. Well, that Robert guy who posted on Snae's video that I was asking you guys about, and FYI, I still have not been able to confirm if that Robert guy is the same Robert guy. And I don't know if anybody here that wasn't here when I talked about this. I'm trying to figure out if there's a way to track a YouTube account and see who it belongs to. I've never seen this guy comment again. I can't find him commenting anywhere else. Obviously, Robert is a very common name. It's just the comments that were being made are very, very odd when it comes to the leak, and then there being a Robert that's involved in this leak. And he said that he knew of the photos back in not the photos. He knew of the runes back in April, May. And let me see what he said. He said there was 3, and he said they claimed that they were, where's my notes? Hold on, I'm going to tell you what he said. He said there was 3 of them, and they meant power, God, and communications. Power, God, communication is what he said they meant. He said there was 3 runes. Am I talking about the comments on Snae? Yeah, that was known years ago. I don't know anything about there being runes that meant power, God, and communication. I was always told that it was ritualistic, I heard that there was something carved into a tree, and I even heard there was an F carved into a tree, but I also heard a K, so I kind of just let that go. I never heard that there was runes that literally meant power, God, and communication. Okay, YouTube comments can be searched by username through the Google search engine if you know how. I don't know how. Maybe I'll send it. Maybe Christine can help me. There are now 3 sources. Imagine having to choose a zombie apocalypse team, and your choices are Keegan, he ain't no snitch, and Judge Scissorhands, and Nick the Slick. So obviously you'd have to pick Keegan. I'm going with Keegan. Right. So but I never heard anybody specifically say that there was 3 runes and that's what they meant. So I have heard all kinds of stuff about the crime scene being ritualistic and things being left. I heard something about that there was potentially something carved on one of the girl. I mean, I don't want to go too far into it, things I've heard, but I never heard like that specific. Okay. So have the rules of professional conduct been violated? Generally regulate, I can't even think. Okay, generally regulate the professional conduct of lawyers. A lawyer must act competently to safeguard information relating to the representation of a client against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in representation of the client or who are subject to the lawyer's supervision. Again, in this case, we have an individual who committed a criminal act. As a general rule, our approach of marshaling all of the discovery and exhibits arising therefrom in the back of the Franklin office demonstrates reasonable care. I guess it's arguable that there may be some semblance of negligence to the extent Mr. Westerman was left alone in the back of the office. Either way, I don't see that there is an intentional act that rose to the level of a violation of the rules of professional conduct. Yeah, the carving was a K. That's why I said I've heard different letters. Is disqualification appropriate? Our client, Richard Allen, has a Sixth Amendment right to counsel of his choice. If the government moves to disqualify defense counsel, the burden is on the government to show that any infringement on the defendant Allen's choice of counsel is justified. At the same time, it has long been recognized that trial courts do have the power to punish misconduct of attorneys and others to the extent that a court would resort to the extreme remedy of disqualifying lawyers. Nearly all of these circumstances involve the lawyer engaging in some conflict of interest. Rules 1.7 through 1.11 generally address conflicts of interest. None of these rules are even applicable to this circumstance. The rules are designed to provide guidance to lawyers and to provide structure for regulating conduct through disciplinary agencies. The mere fact that a rule is just a basis for a lawyer's self-assessment or for sanctioning a lawyer under the administration of a disciplinary authority does not imply that an adversarial party, the prosecutor, has standing to seek enforcement of the rule. Right? Any violations of the rule should be brought to the attention of the disciplinary committee, who would then process the allegations in the normal course of business. Simply put, the rules are not intended to be used as weapons to seek disqualification for tactical or other similar reasons. Did the defense team demonstrate candor to the tribunal? The record is clear that the defense team, upon learning of the information leak, reported this immediately to the court and to the prosecutor. This was done by way of email communications and phone conferences. This conduct is consistent with lawyers' responsibilities, all of which are referenced in the preamble to the rules of professional conduct. Ironically, the prosecutor knew 24 hours before, and look, nothing happened. They didn't tell anybody. I'd love to chat off air what I know about this case since I was owner of group Never Around Now. Yeah, and you send me an email, criminality187@gmail.com. So I think one of the signatures was the weapon, and I think it was like a poker tool. Because of the way Baldwin said AW slowed death and suggested she was like bled. Oh, yeah. Also because of the KY thing. Kentucky or KY? Tactical. Oh, the Kentucky detective said the scenes would lend to the same person have a specific item. Is that the Stevenson case? Is that what you're talking about? That's what I'm wondering if she's talking about the Stevenson case. What are the possible sanctions? To the extent there exists some violation of a court order that rises to the level of indirect contempt, an allegation must be brought. None exists in this case because there's no dissemination of the information by means of public communication, which is prohibited by the gag order. At worst, this circumstance amounts to a breach of the defense's duty to maintain confidentiality of information pursuant to Rule 1.6 and or a breach of the defense's obligation to safekeep property pursuant to Rule 1.15. We believe it is neither, as the acts leading to the dissemination of property were not intentional or even reckless. To the extent the prosecutor believes that there is wrongdoing on our part, the matters should be raised through the disciplinary process. What are the practical circumstances created by this issue? First, the only photograph that appears to have been disseminated amongst the public is that of the F tree. The photograph in and of itself is not overly gruesome. There is no evidence to suggest that the crime scene photographs of the two girls have been distributed to the general public. To the extent they are distributed, the information has already been consumed by the public, as it was specifically detailed in the defendant's recent Franks memorandum filed with the court. Moreover, in the natural course of litigation, there is an expectation that these images will be displayed in the courtroom at a forthcoming suppression hearing and at the trial in this cause. All of these matters are scheduled to occur within the next 3 months. Naturally, the defense's most significant concern is that the victim's family members not be forced to endure the stress and violation of privacy that would come with the widespread dissemination of this information. Unfortunately, the exposure of these images is imminent and part of the unfortunate side of the legal process in cases of this nature. The defense has nothing to gain by deliberately disseminating this information to the public. In fact, the opposite is true. The likelihood of public backlash is significant and serves no legitimate purpose to Mr. Allen's defense. This is what Bob Motta always said. He's like, it's worse for the defendant because then people want justice and they just go, that guy must have done it, so let's get justice, and it outrages people. What are the practical implications of disqualification? They really went all out here. Then they were, as has been previously reported to the court, the discovery in this case involves tens of thousands of tips, hundreds of thousands of pages of documents, thousands upon thousands of hours of video, and the engagement of various experts in different disciplines to address a multitude of evidentiary issues. The defense has been working feverishly over the past year to obtain, consume, and understand all of this information. The defense team has engaged in numerous depositions. Various pleadings have been filed with the court. These pleadings contain work product that has resulted from the thousands of hours spent by the defense team in preparing Mr. Allen's defense. It is entirely impractical to even consider the prospect of disqualifying either one or both of us. It would be nearly impossible for successor attorneys to effectively engage in such a massive endeavor in familiarizing themselves with the discovery and thereafter adopting the work product and theories of the current defense team, and thereafter moving forward with an effective representation of Mr. Allen. We need to see the forest for the trees. Forest for the trees here. Isn't that the name of Chris Todd's book? Forest for the trees? Because I thought it was weird then too, because the saying is like forests. I don't know. That's just weird. Maybe it's just a saying from there. I don't know. That's weird. There is no doubt that the breach of security warranted immediate attention and necessitates some action to try and stop the further dissemination of the materials. However, this breach simply does not rise to the level of disqualification, which would naturally unduly delay the administration of justice for Mr. Allen and the victims' families. And 10, context for the court. Again, both Andy and I accept responsibility for this lapse in security. It is, however, important that the court have a better understanding of the totality of sensitive information that is in the hands of the public. We do not view this as a tit-for-tat circumstance, but I do think the court needs some general understanding of the amount of information that we believe has been previously disseminated by law enforcement officials. Naturally, it is almost impossible to regulate the disclosure of sensitive information unless there's some direct evidence that it is occurring by way of statements to the media, which are then shared with the public. However, in order to bring you some context, I'm asking the court to spend 5 minutes watching a portion of this video associated with the following link. Oh shit, I need that video now. That's not a hyperlink, it's just a copy. This link will also be emailed attached in a separate filing with correspondence, as I don't expect you will be able to access the link in this letter due to formatting issues. We need to get that link. I wonder if I can't even copy it from here. I'll have to change it. Can one of you guys screenshot that and go type it in and then send me the video while I'm live? Is anybody that can do that? I'll blow it up even more. Or somebody can just type it in. It won't let me copy and paste either. I want to see whose video it is before they take it down. Because once they know the video's in here, it probably won't stay up. Let me just see if I can type it really quick. Why did I not get anything? Shit. Go back to you guys. The careful typing. I know it. I already screwed it up. So frustrated with myself. Let me go back and do it again. Listen, let me look and see if one of you guys already did it, so then I don't have to waste your time. Okay, you guys, nobody's got it yet? Okay. Shit, hold on. You can hear my careful typing because I don't want to screw it up. I'm like, there's too many stupid little letters. All right, let's see if I got it this time. No, nothing's coming up. What the fudge? Do you? Okay, let me check real quick. Nope, don't want that tab. Come on, freaking load. I'm just getting a circle. Hold on. Ignore that. Okay. See, that's what I'm like. It's not working. I'm gonna have to look for it later, I guess. If you guys find it, oh, never mind. Maybe she has it. It's already gone. Seriously? No wonder it wouldn't pop up then. No way. No way has it already gone. What the fudge sickles? It's Court TV? Jeremiah says it's Court TV. Do you know what video? Christine, did you write it down? All right, let's keep reading and see what it says. In order to bring you some context, I'm asking the court to spend 5 minutes watching a portion of the video associated with the following link. This link will also be emailed attached in a separate filing with correspondence, as I don't expect you to be able to access it due to the formatting. Oh, it is. It's a segment from Court TV. I probably should just continue reading before I stop myself. You guys, I don't know why I do that to make my life even harder. This is a segment from Court TV broadcast wherein reporter Barbara McDonald communicates with the host information regarding the sticks that were placed near the girls' bodies at the time of the crime. I would encourage you to watch the portion that begins at about the 10-minute mark and concludes at the 2:30 mark. During this segment, you will see Miss McDonald articulate that sources close to the investigation and provided me with drawings of what they say those images look like. So she further reports that she has spoken to many investigators who were on the scene at the time who say the assumption was the sticks, were randomly placed. She then goes on to share with the host the actual stick formations she claims were provided to her by individuals close to the investigation. I can tell you that these formations are the same formations that were contained in the missing Purdue report that was generated by the state's consultant on Odinism. We recently filed pleadings articulating that this report was handed to us a few weeks back. It seems obvious that portions of the report were shared with the media at some point in the past. Ms. McDonald, I think it's MacDonald, isn't it, was also aware that the sticks were not immediately secured as evidence by law enforcement authorities, a fact that could only be learned by reading the incident reports or speaking with the investigators. So she was right. The point here is not to debate the relevance and significance of the stick formations. The point is to demonstrate to the court that there has been, throughout this entire investigation, sensitive information provided by law enforcement investigators to the mainstream media. Frankly, the defense doesn't have the time nor the resources to police these breaches of discovery to the media. It is a natural part of the landscape with this high-profile case. We are simply trying to make the point that members of the general public and the mainstream media have had their hands on various sensitive materials involved associated with this case, and it is virtually impossible to manage the dissemination of this information without incident. Finally, to the extent that these photographs are actually published in a widespread manner, this would not in any way prejudice the state's ability to prosecute Mr. Allen, nor prejudice Mr. Allen's ability to defend himself. Again, we are hopeful that this doesn't occur because of the impact on the victims' families. But to the extent it does occur, it would not result in any prejudicial impact on either party. In sum, this is an unfortunate circumstance which does require some remediation to try and preserve the dignity of the victims. It is not a basis to disqualify either Andy and or myself at this juncture to the proceedings. Obviously, to the extent you would like supporting law, I would be more than happy to offer up the same. The intent here is to simply communicate in writing our position with regard to these circumstances to try and bring some context to the situation so we can engage in some effective mitigation of the breach and move forward with the orderly and efficient disposition of this case in January. I mean, that was very nice. Let me see what this is. Oh, that's Richard Allen's letter. It's so big on my screen that it's like hard to like see what it is. It's like watching it like on a big screen. It's weird. This is beyond tragic. This is that's the emails. We've read through all of those. This is still just so interesting to me. October 8th. October 8th. Go back to the timeline there because on October 8th is before. How did she know about these guys? Their conversation was the 10th in the afternoon or the 8th in the afternoon? Let me look really quick. My daughter just walked in. Give me a second. Hold on. 1 second, guys. Okay. She just got home from school, so she had to tell me how many, all the things that she had to do. Tiny humans always come first. They are my favorite people in the whole wide world. Oh, so that's what I was looking at. The timeline. When did they say that they had the phone call? What phone call? I thought the phone call was the 10th. Was it the 8th? And I'm not remembering now because now I have all this shit in my head. I thought they talked on the 10th. Yeah, the 10th, right? No, so MS said that they got the photos on the 5th, really early in the morning. They contacted law enforcement and the defense team, which they didn't, on as soon as the sun came up. And then the email from Rozzi to everybody is on the 6th. But I thought that they said they talked on the 8th. No, I mean when did McClelland, Gull, and when did they have that phone call in the afternoon? Amy Lou says read. Hold on. Okay, we already have that one. So it's in the email. Okay, so this is the 6th. And this is when he found out. He found out on the 6th. Rozzi did. On the 8th, she's saying that she hopes that the local content creator Rick Snay has been interviewed. And the individuals named Anya and Kevin have been interviewed. But I don't understand how she knew about Anya and Kevin if they hadn't talked yet. That's where I'm at. But that's a whole other thing because I'm going to do a different thing on the leak timeline. Let's see. Can't ignore that Richard Allen confessed 5 to 6 confessions we haven't seen yet. That's a lot of confessions for it to have been a misunderstanding. I agree too. I want to hear them. There's so much around confessions in general. I would like to hear some context. I'd like to hear his tone. There's a lot around it, and I don't think you can't just act like it didn't happen and just call them false confessions. But I also don't think that you can hold them. And those 5, 6 were supposedly in that same phone call that he repeated it, like I did it, or something. Like that's what I did. I want to know how he says it, and obviously we know that he does say something because both teams are admitting that he said it. It's just in different contexts, so we can't really form an opinion on it. Rick's wife supporting him at trial. She knows those confessions were coerced. See, sweet dude should be like. So here's another thing I find very weird. His wife is supporting him. Where's his daughter? Where's his daughter? Why isn't she there? Right. And they purposely said they were holding all that stuff close to the vest so that the person who confessed would know. So we've talked about this whole runes thing like multiple times, and I'm pretty firm on my opinion of the runes at this point. I do think that they were intentional, and I think whoever did it was amateur. And that's actually a lot from what C. King has told me about just runes in general, what I've researched about runes, and then the commentary from that Purdue professor, ironically, who says it's almost like amateur, like so it'd be like kids that are just learning like the acid true, or it's the people who are wanting to join and just trying to impress. They don't really know it yet. It's amateur, no matter which way. But I do believe that everything that was done intentionally. I just don't know what. I don't know what the killer or whoever placed those things there. It's hard to try to say like this is what they were thinking when they did it. Like we can't. I don't think we can really get there yet. But I think everything was intentional. Yeah. I don't take anything a person says while under duress seriously. Well, you can't. And that's part of it. You can't take any confession. The confession, it'll hold more weight because the confession is to his family than it is to than a confession to law enforcement. But I still think that there's something to, maybe we can do a live on it sometime because I had to write one of my papers. It was a big ass paper too. It sucked. But it was good information on false confessions and why people commit false confessions. And one of the topics that I actually covered was people will, what do they call it? like to get their loved ones to move on and to not sacrifice the rest of their lives. They will tell them, like, I did it. I'm a terrible person. I did it. Leave me alone. Like, just move on with your life. You've got to go. You've got to move on. And it's almost, it's like, it's supposedly to help them. And that sounds crazy, but it's true. And it happens. That's why I want more information around the confessions before I make any decision whether I think they're okay or good or not good. Or let's see what else. Does she have small kids? Shit, Sleuthy, I don't know who you're talking about. Okay, so let's talk. We want to talk about how was anybody aware? How was anybody aware that Robert killed himself? How did anybody know that? Who told them that? Where did it come from? Was this because somebody was friends with Robert and the wife told them? There's something to how did anybody even know that this guy did this? How did they know that he was involved in the leak? Okay, we could say Mark said Robert sent him to me and Robert's friends with so-and-so and maybe somebody gave him up. Okay, fine. How does anybody know that this guy kills himself? It's not like they put it on Facebook or Instagram. Yeah, they live fight. I know. Oh, I know. There are basics we have no way of knowing about the case in general. True. Yep. It is a small town. So that's how they knew? Because it went around town that that's what happened? How did Gray Hughes know? He doesn't live there. Somebody that lives there told him? And they all just happened to know this guy was involved in this leak. It's just, that's just very strange to me. He was there between 12 and 1:30, not 1:40 and 3:30. A group of 3 girls saw him around noon. The group of 4 saw a different person later. R.A. Carr was not seen between 1:30 and 3:30. So I'm not in disagreement with you, Kayla, at all. I think they're going to have to do something more for a jury to see that he was there between, 1:40 and 3:30, as you say. I say 1:30, 3:30, because in their own documents they state it differently. They say that he was there between 1:30 and 3:30, and that he was there from 1:30 to 3:30. Those are not the same thing, and that's what they state in their own documents, not the defense team. The guy's friends. Well, yeah, he broke the news to him in an email at 4 a.m. Yeah, I think so too. So that's one of my biggest questions is about the timing that Richard Allen would have been there, because, and people are like, well, he came back in and he changed the time because he now knew what they were looking for. But it's like, okay, well, why didn't he change anything else that he said then? If he changed what he said about what he was, why didn't he change what he said about what he was wearing? Why didn't he change what he said about where he parked? Why didn't he change anything else except for the time? That bothers me. So if it's just to cover his ass and be like, yeah, they know I wasn't there, or they know I was there, so I got to change the time. I'm not sold that this guy's innocent. I just want a couple more pieces. I want a couple more pieces because the eyewitnesses not reliable. Essentially, you can almost throw out all the eyewitnesses at this point because nobody knows who they saw. Nobody picked Richard Allen out of a lineup. The majority of them have, I guess, essentially said they probably couldn't pick anybody out of a lineup. They're all saying that that the person they saw matched the person on the bridge, but yet the person they saw doesn't match the other people that the other people saw. The eyewitnesses to me it's done. I can't even talk about the sketches and the eyewitnesses. They don't make any sense. They don't add up. You're going to have something more than that because that's too easy for the jury to say, well, you think you saw this person and you think you saw that person, but those two people aren't the same person, so how can they both be the person on the bridge? So I don't think you can sell it that way. I would not buy that as a juror. I'd be like, okay, so which one am I supposed to believe? Do I believe the 16-year-old group of girls? Do I believe the lady driving by at 40 miles an hour? Do I believe, the other girl who saw the young guy with no hat and puffy hair or poofy hair? Do I believe the ones that saw the guy wearing a hat and then the one later on was wearing the hat? So is that the same guy? I just can't. That's why I'm like that. The eyewitnesses to me they're shot at this point, and some of them not giving statements for months or even years. Whew, He is innocent according to the law, absolutely. Just like Brian Koberger, even though I think he's the right guy. So, at this point, a juror could find him not guilty. If we went to trial and all we had was what was in front of us right now, and we don't have anything else, there's no way. I cannot see this man convicted. It just makes no sense to me. So we still don't know if they did any type of geofencing. We've heard different things, but we don't actually know it. In any documents that I've seen, we cannot show that they did any type of geofencing to see if his device actually shows up there. That would be a big deal. We also don't know if hold on. I just saw a comment there. Police have 43 seconds of video. We've only seen a few snips from it. They also have all the recorded confessions as jail phones are always recorded. Can't wait to hear that. Yeah, me too. And so the 43 seconds is also an interesting thing too, because depending on which family interview you listen to, some of them will tell you that is all the video there is. The rest is only audio. And it's mostly of the girls. And then other people were like, no, there's still more. And then now I'm hearing that there's even more pictures from the trails and so on and so forth that we haven't seen. So I'm also curious about that. That's why I'm like, once it goes to trial and we're presented with some more evidence, if they have something else that ties him to being at the scene of the crime, at the time the girls go missing, that's what I need. I need something. I need something besides these eyewitnesses. Oh, we're down to 2 sources? Well, so, and that's another thing. If you go with the confessions, then how do we discount that Elvis confessed? If we only go with confessions and Elvis confessed to his sister and he confessed to his sister before the bodies were even found, and then tries to get the other sister to take his coat and says, I'm going to be in big trouble and I'm probably going away for a long time, but I've got a new group of brothers. How do we just say Elvis is not reliable then? We have to take both. And you can't take both unless you have a tie between those two. So somebody's making shit up, right? Hi, Schmeed. Oh, did he? I have questions for him too. Brian Koberger hasn't confessed a single time. You're right. But Elvis has. That's why I'm like, I don't know. 2 people have confessed to this crime. Right. 2 people have. So which one do we go with? Hey, Metabomb. It's so tough too, because I also feel like they probably shouldn't have released. You guys are okay. So one of the things that I've been working on is I'm trying to piece together these damn interviews, but taking all the nonsense out that we don't actually need, just the stuff that has to do with the crime, with the day of, with the the important facts around it, and it's so weird to me because this video, the cops say, or the picture of BG, not the sketches, the actual picture on the, like, of him on the bridge. You have Riley who's like, okay, take away the hat from the sketch and just pay more attention to the face on the camera or on the video, and don't pay attention to the sketch where the hat is. Just pay attention to that. And then you have Doug Carter who comes out and he's like, okay, take the head off. Just take the head off and just pay attention to the body. I'm like, they can't even figure out what is going, like, which part to pay attention to. Just proves he was there, which he admits to. Yeah. Hey, Julio Suave. And replaying crew jumping ahead because there's so much to say here. Firstly, Sleuthy is a boss. Yes, she is. Yes, she is. There were 4 girls BB saw. One was the little sister. The group of 3 girls was around noon. Yes. So I want to know, Kayla, can we find or prove there was a group of 3 girls that were there around 12:30? Because that's what nobody talks about. We talk about all these witnesses that got there after, but nobody talks about, like, everybody who was there in the morning. And that's where I really want to figure out who was all there before this happened. So is there a possibility there was 3 other girls, a group of 3, because we know there's groups of girls out there, there's groups of guys out there, groups of girls out there. Is there a group of 3 girls that would have seen him, that he would have seen earlier at about 12:30 when he says he got there? Now, if there is a group of 3 girls, do those 3 girls say, yeah, we did see this guy. We saw a guy that looks like XYZ. Right. Who was there earlier? That's what I want to know. All right. And then I'm going to wrap it up. I've been on here for 3 hours with you guys hanging out. So we know that they already came out and the Supreme Court has ruled that any opposing information be given to the Supreme Court, the Supreme Court Justice Loretta Rush, by November 16th. So they have a couple deadlines that they have to meet to for the Supreme Court before we're ever going to hear anything else at this point. What's the other one? What was the other one? The 10th? I can't even think anymore. Did I pull them both up? No, I doubled that one. I think it's the 10th. The 9th. Maybe it's the 9th. Somebody tell me. This is why I have to end this, because I can't even think anymore. Oh, my King of Kings, I appreciate it. Then every single man, woman in prison and jail are under duress just because they are locked up. No, not really. But if you're innocent and you're in prison, you might be under duress. Hey, Johnny. Thanks, Lilith. Oh, my King of Kings, you're very welcome. Well, there's part of them I had to go through too. So I prefer doing it with you guys because then we can kind of bounce things off of each other. Hi, Tiny Human. Did you already have an Oreo? What's the chocolate on your face from?
This?
Uh-huh. Because you already had an Oreo? Yes,
Yeah,
you can.
This is my first Oreo.
You can have it.
Can I have another one?
You can have one more. Yeah.
I
Uh-huh.
always have 2 with 1 Oreo.
Okay.
So, normally 1 Oreo,
Uh-huh.
I take apart like that,
Uh-huh.
and the second Oreo, I eat normal.
Okay, perfect. You go have your second Oreo. I'll be there in a little bit. Tiny Human.
I'm not tiny human.
You are. You're my tiny human.
I'm not daddy's tiny human.
All right, you guys. What was I don't even remember what I was doing. So we have 2 orders by the Supreme Court that we're waiting to hear what they end up determining. And that's that's kind of where we're at. So we'll see. We'll see what happens. Hopefully I'll have these edits on these videos. It's taking way longer than I thought it was going to. So I apologize for that, because I was really trying to just trim it down to show you guys just the important stuff. And then that way it can just be there and you don't have to listen to all the other craziness that goes on. And like all the just commentary in the interviews. They're just taking a really long time. So I apologize for that, but I am still working on it. So I just want you guys to know that. Hi, Jinlu. So I will be back mañana, and we'll figure out what we're gonna talk about then. I've been trying to catch up on the Charlie Adelson, Adelson. I don't even know how you say his name. I know they were doing closing statements today too, which I haven't got to watch because I was too busy reading all this stuff. But we'll be back tomorrow. We'll talk about something. We'll see what happens with Delphi. I'll talk to you guys later. Oh, and make sure, I know that if you guys want the lawyer side of this, Bob Motto will be live at, let me just double check when he'll be live so I can tell you. $6:45 Pacific. All right, I'll talk to you guys later. Go enjoy your day, and thank you guys for spending your afternoon, early evening here with me.